Sir, you're charged with especially aggravated kidnapping. You're also charged with aggravated assault, and you're charged with theft of a firearm worth less than $2,500.
You're talking about stuff that is not relevant.
Hello and welcome to the Court of Public Opinion. I am the Recovery Addict, and boy do I have a case for you today.
Why is the dog chewing on this guy?
I think they have got the wrong guy there.
Got the wrong guy, and the dog was biting him.
He roughened him up quite a bit. There's a lawsuit.
9 out of 10 judges prefer watching the Recovery Addict live stream in their courtroom. The fireworks are not done.
Now we're getting commentary on the case. Dati mihi Anglican for in service of
By gosh, go down and fight them.
So here I am once again trying to go live with my camera not turned on. That never works. We'll give it a minute. It might catch up. All right. Good morning. Welcome to the Court of Public Opinion. I am the Recovery Addict. Thank you very much for joining me today. I appreciate all of you for being here, especially today. If I can get this working. Man, my camera's not turning on. Keep your fingers crossed, guys. This might be the time. Okay, it's warming up. It's warming up. All right. Did Mrs. R.A. get her exercise in? Yes, but I can't use that as an excuse for why I am late. As a matter of fact, I can't even put chat on the screen right now because I'm so late. Hang on one second. Let me get the camera working first. All right, so we have our camera. We have that camera. We have nearly everything else. Let's see. We have chat on the screen. Whew. And I'm just after the intro music, so it's almost like I'm on time. I'm sorry. Excuse me, says Mandy, right? Yeah, just come on and just push past, get to your seat. It's all right. I'm late, so it's okay. I have to give a huge shout out to Ivan Victor. Ivan, first in chat last night. When we first put the live stream up, Ivan was first in chat. First in chat comes with its own prize, punishment, or penalty, depending on how you view it. The first in chat, you have to, in addition to being responsible for every comment that comes after you, you're also responsible for everything IP related. I forgot to tell you. This is the first time I've let you know that you're responsible for all the comments that follow you. So. Ivan, thank you very much. Good friend of the channel, been with us for a long time. Appreciate him being with us today. If he is, I'm not sure if he's even awake now. He was up late last night. So hopefully that's the case, Ivan, because you have a lot of work to do today, making sure the internet runs for everybody worldwide. Congratulations. I am blurry. I'm focused on my side. Does that help? Now, Ivan's responsible for comments. Red Pen says we're in trouble. Oh, man. Ivan, he's barely responsible for his own comments, right? How can we put everyone else's comments on him? Ivan's a great friend. I appreciate him. All right. That being said, let's see where we're at. I think we might have some birthdays today. We have court that's going to start about 8:30 with a little bit of business, like we had the business yesterday, and business yesterday was eye-opening to be sure. Let's see here. We've got, let me find this here. Waiting. Is that the right one? Yes, it is. Okay, we'll keep that one there. Let me check my other feeds to see what we have available there. Let's shrink this one down and refresh this guy. Does anybody have any birthdays today? Anyone else hearing an echo? Are you hearing an echo? Test 1 2. Test 1 2. There was a bit of an echo during the very intro because I had a loop going, but no echo. Maybe you have two devices playing. That's always approved. Back camera is blurry. Let's see. Not that one. This one. It did turn on with a very grainy exposure. Let's see if I can get it to autocorrect. This is Brandy's trick. Is that any better? It's the exposure level that's causing problems. This is what happens from shining a bright light into the camera into a dark room, but the light is off camera. There's something floating in the air. Do you see that? There was like a bug or a spider that was floating by. Now I'm worried that it was a spider. Maybe it was a bit of fluff. I don't know. We'll see if we can get that sorted. I think maybe a little light might help it. Nope. It's the fact that I just barely turned it on and it does not want to play. We'll give it a little bit. It'll wake up. All right. Did we see anything? Did we see anything birthday related? Happy birthday to all celebrating today. Let's see. I have 0 birthdays today, says Greeners. Anybody that does have a birthday? Let's see, look at this. Shark Snack Gulf Coast. 6 months today. Look at that yellow courthouse. It looks great. Thank you very much. Let's see. No. We're good on all that. Let's reset this. I think we're set to go. We've got to figure out this back camera. It's a little frustrating. I hate that it's grainy like that, especially because it's able to shoot in 4K. There's a buffer. Okay. Sunshine 6431 has a birthday on Saturday. Rudy Patooty's grandson also has a birthday on Saturday. Rudy Patooty, is there a name you'd like us to sing to, or just to Rudy Patooty's grandson? Seems a little better, says Nate. Let's see. I think that's it. If that's all we have, we'll go ahead and sing just to those two. Let's see if Rudy Patooty can give us a name here really quickly. Colleen Kelly says, where can I find information on renewing membership? I read a comment yesterday about renewing, and I don't have any information on it. Thanks. Colleen, the membership, if you were gifted one, it does expire after 1 month. If you purchased one yourself, there's generally it can be done with a recurring purchase, or if you click on the $ at the bottom of chat, I think it will give you an option to view membership. Let's see. I'm trying this here. Let's see. We've got super sticker, super chat, and membership. I think membership is on there. If that's not working, at the very top of the screen there should be a little green bubble right now, because guess what? 7 up here. Member for 9 months. 9 months. Does that mean I'm born again? I love being here. Thanks, dude. This is 7. I think this is the first 9-month membership mark we've seen ever. This is fantastic. Thank you very much, 7, for that. Anyway, you can click on that little comment, and you might be able to right-click or see the three little dots on it and say membership settings. Son's Ryan's birthday is tomorrow. Okay, Jennifer, I'm going to add this to it. Hang on 1 second. Okay, so we have... Oh, now I forgot the other ones. 9 months is huge. We're going to have a flood of 9 months, because I think 7 was a day one joiner when memberships became available. Let me back up a little bit. Who did I miss? Where's the buffer? There it is. Sunshine. Ryan. Sunshine. Rudy Patooty. Grandson, which I'm looking for a name on this. Where's the buffer sound? Dominic is the name. Okay, got it. Just say Dominic. I know, I'm messing everything up. We're going to get this done because court's going to start in a few minutes. Let's see. I think that's it. So just the 3. We have to go quickly because the court we're seeing the flagpole. Dominic is a cute name. It's awesome. Let's get ready to let's not show the test. That's no good. Let's just show this part. Actually, let's stay right here. Okay, we have to sing right now. It's happening. We're going to interrupt the judge if we have to. Okay, here we go. It's going to be Ryan, Sunshine, and Dominic. Everyone join in. This is not a solo. This is a sing-along. I will know if you didn't sing. YouTube tells me. Okay, here we go. Happy birthday to you. Happy birthday to you. Happy birthday, Ryan, Sunshine, and Dominic. Happy birthday to you. Ryan, Sunshine, Dominic, happy birthday. This is your special day, a day to celebrate you and your great accomplishments, specifically surviving another year, which is something to celebrate. It really is. I realize there are many places you could do this celebration, including, say, Denny's, who offers free breakfast sometimes for people who are celebrating their birthday. If that's the case, it's not a bad thing to do that. But I realize that you're here instead, and that just makes me happy, and all of us as we get to celebrate this special day with you. Thank you very much. Have a happy birthday. And with that, we're going to get ready for court. They scared me because they turned the audio on. That was a little rough. So, wow. All right. Tricia Fishburne just gifted 5 memberships. Thank you very much, Tricia. That is a great start to the morning. Look at this. Jen, Amy Flotter, Dreama Laundry, Jennifer Dunn, and Sue R. Mamasaurus, all gifted memberships thanks to Tricia Fishburne's generosity. Thank you very much. Let's see, Nursey Dog Mom. This was a point of contention yesterday. We're not going to argue it here in chat because this is the least effective place to argue anything. But ketamine not addictive. The doctors coming out. No, there's no problems. First of all, I do feel that pretty much anything we add to our body that is not natural, as in not naturally occurring in the body, and even sometimes if it does naturally occur and we add extra amounts to it, it causes an imbalance somewhere, and it causes a reaction or some sort of action with, for him to say that basically no amount of ketamine given to anybody has any problems, I think there might be more to be said there. That's all I'll say. But a couple people took issue to the addictive part, but we'll learn about that as we go along. And there I have the hiccups. I'm glad I didn't have those in the during the song. All right. Okay. Now it's not time to exit. We're actually entering right now. See, there's the flag. So it's all good. Very panicked. Happy birthday to you all. So it's Haunted Pizza. Good. Tammy L here for 3 months. 3 months. Thanks for having me. I enjoy spending my work days with y'all. Happy Friday. Tammy, if you're willing, let us know what genre of work you are engaged in. We'd like to give a shout out to your coworkers if they're listening as well. Let's see. CC Reagan says not buying it isn't addictive. Love this channel and Mr. and Mrs. RA. Thank you, Tricia. Appreciate that. Mrs. RA is fantastic. She has her own channel. I think she needs to start a second channel for her, a third channel for the family. Because she has so much great insight and information on so many things. First of all, I'll tell you why. She's extremely well read. For those that just watch every week, she'll go to the library and she'll check out books, and it's not like 1 or 2 books. She'll check out like 7 or 8 books every week, and then she'll read them all during the week, and she'll read them all while she's also, she'll read some of the kids' books as well. They'll check out a couple of books. She's like, oh, I'll read that one as well. And she just devours books, and her mind is like a trap. She just has all this information that she retains. And so when something comes up, an issue comes up, she's like, oh, I've read about this. I've read of, all the historical works that, that led up to the forming of the Constitution. I've read all the Federalist Papers and everything. And she just knows all this information. I cannot debate her. I would never ever win, just because I just don't have the breadth and depth of knowledge that she does. So it's fun. But when she comes on chat, I just agree because she knows more than I do on just about everything. Okay. The best testimony says Nicole. The best testimony was yesterday when the doctor said the jury needs to know the truth.
Am I the only one who keeps thinking they're talking about calamine lotion?
Heidi Ho to you says, am I the only one who keeps thinking about they're talking about calamine lotion? Ketamine, very similar but different. Yes, Nicole, when the doctor said that, that was another moment. I guess we could say that the doctor probably should have been sort of chided by the judge and said, hey, stay in your lane. The roles of we're all playing here are important. So That was good. If you guys missed out, Brandy tweeted a beautiful picture of her morning sunrise with the moon. Well, it's the moon set during the sunrise because she's looking over the Gulf. But the full moon over the Gulf. I think it's like a harvest moon or something. It's like the third full moon, fourth. Oh, the judge is typing his password. Hang on. PASSWORD 123. Enter. Yes, it's working. Okay. Anyway, Brandy tweeted out this picture. I replied and I said I would trade her a picture of my neighbor's tree, which is what I see on my window. I sort of fibbed because I took a picture of trees that are around the corner.
CA 5321, Jack Kowalski, etc. et al. Versus Johns Hopkins Children's Hospital. Starting with the plaintiffs, let's take appearances, please.
Craig Anderson, Nick Whitney for the plaintiffs. Ethan Shapiro, Howard Hunter, Pat Crowells, David Hughes, and Dr. Elliott for all children's.
Thank you very much. I've been handed an exhibit list. It looks like most were agreed to, but there's a couple that were not. Do you want to address those now?
Sure. Yes, Your Honor. The first one is 2658, which is a yes but objection to audio. It's about 4 minutes long, and I think if the court watches it, you'll agree we are not offering any of the statements in there for the truth of the matter asserted.
I hate that. I hate that argument.
Maya Kowalski making noises, and she says at one point, a couple times, "Giddy up, horsey," which is not exactly what I would call massively prejudicial hearsay. And so if the court would like to view it to see, because it is important to have the audio with it to put it into context.
It's not just Maya speaking, her mom is also on the video by voice.
Trying to get the, there we go. Okay, let's go ahead and
let's watch
play
it,
please.
You can do it. You can do it. Woo! Mom! Come on, ready? There she goes. She's getting up. Hurry up. Hurry up. There she goes. Come on, giddy up. You help right there. There you go. Okay, come on, left. Lefty, come on. Let's go. Come on, you did it great. You don't believe me? We'll do that. Let's go. Come on, left. There it is. That was great, Maya.
What is this going on?
Come on.
Love it.
Yeah. Very good. Very good.
Maya.
Very. Giddy up, Percy.
Giddy up, Percy.
Giddy up. You don't believe me?
I do. Come on. Good.
Woo!
Good.
Good. That's it. Maya, that's awesome.
Very good.
Okay.
You almost by mommy. Almost there.
I was going to tilt her that way.
Yeah.
There we go. Here we go. Whew.
You both are getting a workout, aren't you?
Yes.
Do you want me to put the stool close by you, Marissa?
You know what? We are almost here. Well,
okay.
I can make it.
All right.
We can make it. Let's go, Lefty. Come on, Lefty. Come on.
Come on.
Come on, Lefty. Just go forward. Go forward.
Okay, pick it up. Good.
Is that straightened on your own?
That was good.
Can you press up a little bit for me? Giddy up, Percy. Go.
There you go.
Come on, ready?
That's how much fun this is.
Come on. You're doing it.
Toes forward. Toes forward. There you go. All right. Come on, Lefty.
I think that's pretty much it, Judge. I mean,
Is that pretty much the...
Yeah.
That's pretty much it.
Okay, let's go ahead and stop it. Ms. Quarles, what's the objection?
it was hearsay, Judge.
I don't think those statements are being used to prove the truth of the matter asserted. I'm going to overrule the objection. The audio will be able to come in.
Wow.
And then we also have, Judge, 2694, which since the defendants have used it in there, well, you're not objecting to that.
Well, Judge, they added it this morning. I haven't had a chance to we hadn't had a chance to discuss it. They added the last one this morning. So
it's only, how long is it? A minute?
2694 is 1 minute.
We can show you.
What is it? How long is it?
1 minute.
Let's just play it.
Yes, sir.
Hi, Megan. This is Maya, and I have RSD. I'm unable to walk, and when I hear your songs, it makes me feel better when I'm dancing.
This is, unfortunately, I have to mute this because I'm about to get a copyright strike, which will cancel my channel. I apologize. This is a weird situation we're in. So I have to mute the audio here from the channel because the music is, the audio part is huge. Yeah.
728:16.
we don't object to the video. Except for the beginning little
I don't want to strike. Don't want to strike.
Really?
Well,
I can only play a couple seconds of music without having an issue.
What are you doing? What witness is this video with, and how's it going to...
It will be through one of the neurologists who treated her around this time, and will testify that
seriously
her behavior here is consistent with the progress he noted in his office and his physical therapist noted.
And also, we'll probably put it in first with the first witness, Melissa Higgins, who is the physical therapist that took over right at this point.
That's not.
But how about the comments at the beginning that is a shout out to somebody else?
Yeah. Hang on. You know what? I'll withdraw it at this point. But is that what you all want? I'll withdraw 2694.
Oh, so we're not going to have the music.
Yeah. And there are a couple others. What are the other issues?
Okay, so we had 2 objections so far.
We've got, let's see, 2781 screen. No objection. Sorry.
Judge, I don't know what the audio is on 2660. I just couldn't get it on my computer.
Let's put a 2660. How long is that one?
30 seconds, it says. I just don't know if there's audio.
Let's just play it, please.
Air hockey.
Oh, nice.
That's fine.
Objection on that one.
The other 2 are Meg Boland texts and communications with Beata Kowalski.
So 3 more
Facebook
objections.
Messages back and forth.
Let's put up 2781.
The Curnow kids, yes, I think that was a big thing. Let's see what this comment is.
Just to remind you.
How many pages is this document?
23.
Well, can you scroll next? How is this? What exceptions are you purporting to use?
This might be a tough one.
It was, I'm sorry.
It's clearly hearsay.
Yeah, I understand. Would it be all right, because I hadn't really thought through this, I want to cut this down to about 2 or 3 of these that I think are admissible. I can either try to do it
Under
right
what
now
exception?
and get it over, or we can take it up before the witness she'll be the last witness. And probably if Dr. Barr and Dr. Spiegel go as long as we
what I'm hearing is for 2781, it's a witness in the afternoon.
Yes, sir.
And you want to narrow 2781?
Correct.
Okay, so that's fine. Perhaps at lunchtime you can tell the defense the specific page or pages, and then they can refine their objection. But
I will.
Okay, is that for both 2781 and 2782?
Yes, sir.
Okay, so at this time, am I able to receive the ones that were agreed to?
Yes, and we would move to admit.
Okay.
What is it? 529.
Hold on a second.
3.
Hold on a second. Any objection to the ones that say stipulated here?
No.
Okay, so the court receives 2529-23, -25, -31, -34. The court has received over the defense's objection 2658, and then it seemed like the defense removed the objection, so the court will receive 2660 at this time.
Tammy, thank you very much. 5 months. That's
What's
amazing.
next?
Thanks for the kind words.
Your Honor, you're not going to be a fan of me here, but we added one photograph and showed Mr. Shapiro.
Do you see that?
It's a photograph.
Steam out of his ears.
Let's give us the number.
2530-32, if you could throw that up. And one of our witnesses, Dr. Barr, treated her during this time, and looking at the photos that have been admitted to this point, we don't have one contemporaneous with his treatment. So that's the purpose of this photograph.
Judge, our objection would be cumulative. They just put in
I don't see what this photo does other than it's just a picture of a smiling mom and daughter. It doesn't demonstrate, we've got tons of evidence that she was in a wheelchair.
Our position demonstrates her status at the time of his treatment. We don't have
2530-32 is cumulative. What's next?
Do you have anything else to make? I don't.
Nothing.
I need to go check and make sure I got a witness.
I need to check and make sure
Are
they
there
have a
issues
witness.
from the
he
defense?
says. Yeah, that's sort of important.
No.
Madam Clerk.
If the plaintiff could produce 2658 and then 2660, so we can mark it, John.
I think Kelly will take care of that.
As soon as she returns, Your Honor, I'll.
So Maya's here. Kyle is here.
I do have a question.
Looks like Jack is sitting next to Kyle.
To the plaintiff, if during the examination of the physical therapist from Tampa General, Ms. Higgins, are you putting in the Tampa General records or no?
We have a witness.
That's a Mr. Anderson question. I don't know the answer. Sorry.
No problem.
The question is, are we putting in the Tampa General records during Marissa Higgins' testimony?
I'm not planning to at this point. There's a lot of them. How many pages was it? How many pages is TGH records? Is like 1,000.
I guess my question to the plaintiff would be, are they putting in her notes or no?
I hadn't planned to. I can, if necessary, to orient her as to time. It's over 1,000 pages, and frankly, there are some objections that need to be dealt with on that. And so I chose to not put them in. I may refresh recollection if she cannot remember the date, the specific date she started and ended. That's the only thing I would use them for. It would be for refreshing the recollection of the witness, and not as to any. And I would not move to admit them.
I know the court has the ability to show her a record without publishing to the jury. We will be moving to admit the Tampa General records in our case. The best I can do on cross-exam is just ask our technologist to be able to publish her records to her, so I can ask her about the records without publishing them. But
Well, I'm going to have to control the access. So before if it's something that's not admitted, someone needs to let me know. And because the jury can see that public TV, I'm going to turn the public TV off and the jury feeds. I will leave the monitors for the lawyers and the witness.
That means it also turns off the feed for.
I mean, if you want to do a test, I can show you exactly, and then you can go verify in the clerk's box. Just put something up.
Clay, it would be defense exhibit, for example, 3047.
It doesn't matter what number. It just put something up, and then.
There you go.
Okay.
So now it's on. Now we can see it. The judge turns it off.
Lawyers want to go look at the jury box. You can see that public TVs are off. Your TV should be on. The jury should be off. The witness should be on.
Judge showing he knows how to run tech.
Okay, so that's what I will do, but I just need someone to remind me at the specific time that it's not in evidence. Okay, what's next?
I think that's all for us right now, Judge. For the record, if we refresh, it would be it's defense's exhibit 3047.
S-Web, you've got jury duty. That sounds awesome.
1384. That's the initial eval. And then 3047-1371-1377.
Haley's comment. Sorry, I just missed your. What are you referring to? What does what mean?
It would be 3052 through 3056.
We object to the piecemeal of the records for the benefit of counsel and the clerk of court to be admitting records one at a time in 1,000-page documents.
I don't think he's admitting records. He was just telling you the records that he might use to refresh.
That's all I'm doing.
I apologize, Mr. Anderson. Okay.
Do you need those numbers again?
Yes, please, Your Honor.
Let's see. First eval. Let me give them to you more.
Oh, okay.
Is it 3047?
They're shutting off the cameras because they're going to show something to the witness that is not admitted in evidence. So the jury doesn't get to see it and we don't get to see it, but it will be used to remind a witness of something. The judge has authorized that.
The next ones are 3047-1371 through 1377, and then 347-0051 through 0056.
Okay, thank you.
So,
once it's done, let us know if you can, or if you want to. We'd like to hear how your experience went.
I'm prepared, John.
The next topic, the jury was asking yesterday, and I think what they want to do is if we know there are days that we're not going to be here, give them an opportunity, like schedule doctor's appointments and whatnot. In going through the schedule, the only ones that I know are for certain would be the morning of October 18th, and perhaps it's an all-day.
What day of the week is that, Your Honor?
It's a Wednesday.
Judge, I do have my appointment in the afternoon. I could try to move it to the morning.
On the 18th?
On the 18th. They don't like to do it because it's a short.
That's a day off.
And they like to do it in the afternoon.
Well, what?
We're talking about a day off.
I would just taking the whole day. By that point, I'll be flying in 2 or 3 doctors, including Eli Newberger. I'm trying to get him earlier, and I told you all I was going to try to get him earlier. We got some issues, so I could use that day for planning purposes to travel.
18th.
18th of October.
Yes.
Seriously.
I suspect we'll probably be in the defense's case by the 18th of October.
Absolutely, Your Honor.
I sure hope so.
Yeah. If I can't get him in on time, I would like permission to put him on over. I'm doing everything I can to get him in earlier.
we'll deal with that issue later, right? This second, we're talking about days we know. So it sounds like October 18th, we'll just tell the jury that's the day that they can use.
You missed a couple videos and pictures.
And then
most of those will be shown in court.
I know for a fact November 3rd, and I highly suspect November 2nd. Those are the dates.
We're still talking about 2023, right?
That we have to.
Good grief.
But I didn't think of any other dates that were known can't be here.
Wasn't there something about Friday, Judge?
November, well, that's the 6th. Next Friday?
Right, I thought you said that.
The afternoon.
Okay.
But I can do the morning.
Okay.
And we definitely need to figure out next week's schedule as well. So you want to talk about next week's schedule now?
Today is my 5th wedding anniversary. Second marriage that has been amazing. Purple Heart.
Selena Kay, congratulations on your 5th anniversary. That is awesome. Good to have you here with us.
All right.
Congratulations.
There's going to be another buy lunch. We'll.
We're a strange bunch when we get excited about a jury summons in the mail.
Are we having a hearing on Tuesday, Judge?
Well, that I anticipate us talking about the late disclosure issue.
Okay, so that's the big one on Tuesday.
I don't know if we're doing that at lunch, if we're doing it after evidence, if we're going to do it first thing in the morning. But I wasn't going to not bring the jury. I mean, I'm going to bring the jury.
Courtney, it depends what other trials start.
I will tell you, based on how we're going, I think it is okay.
We may switch to another trial and then catch up.
Have
on
the
what
jury
we missed.
not here 2 half days. So we know the afternoon of October 6th. So in my mind, the question is, do you all want a half day someplace else during that week, or just have the 6th as a complete day? And that's something you all need to talk amongst yourselves as to what makes sense.
The complete day.
I'm sorry?
I don't need to talk. I'd rather have the complete day.
You want the complete day, even though that means
I don't know.
we'll do
I don't know
Monday
their
through
total hours.
Thursday as full days. And then why don't you, Mr. Anderson, talk amongst your team and then let me know at lunchtime or after lunch your thoughts.
I would prefer, just knowing what I know now, to take an afternoon on Wednesday the 4th. I'm going to take us 2 afternoons next week. In defense of that, I think we've been pretty good about bringing witnesses in, and it also gives the court, everyone else, some time about these depots. We haven't played a single depot yet, and we probably should look to do that. So I was thinking the afternoon.
6 months, Carolyn. 6 months is yellow.
Why don't you all talk at lunchtime and see if you come to an agreement? If not, I'll
The judge
make
says
the
this so
final
many
decision.
times. Could you guys just talk to each other and sort this out? Just talk to each other. Can you see if you can reach a conclusion together? Can you find some place to agree? It's like he's like the recess lady at elementary school trying to stop fights. Can't you guys just talk to each other?
10/18
all day
off November, probably 2nd and certainly 3rd, and then we're also going to be off at least in the morning of 10/6, or is it the afternoon of 10/6?
The afternoon of 10/6.
And our option now is to do a whole day off on 10/6 versus another half day somewhere.
Somewhere next week.
Somewhere next week.
The flowers arrive on the 2nd, Julie. I told everyone the wrong date.
And
I thought it
when
was
I
the
say
28th, but it's the 2nd
off,
we decided on.
When we talk about, that half day, we might end up having to do legal argument or something, but I'm telling about the jury.
Yes, sir. I understand. And I just,
This is
I've been asked to produce one of our doctors on Wednesday. If counsel wants the afternoon off, I'm assuming she'll need to be in the morning. As far as I know, that's fine. I just want to kind of throw that out there, that fact.
I can tell the court one thing. I'm going to likely put on either Maya or Jack Kowalski next week.
Next week.
Have them fully prepped so it goes smoothly with the exhibits. I could really use either a full day or, and my problem with half days is, frankly, we get into it and it's a direct and a cross, and then the next thing you know it's 3 o'clock, and by the time we get home it's 4:30.
Based on how you all are coming, I am okay with 2 half days. I don't care so much if you want to put them as a full day or not, but I'm just trying to be, I don't want to say kind, but trying to be recognizing this is a marathon. You all have a lot of things going on, and I'm just trying to keep the case moving, but at the same time not wearing you all out that you become zombies.
I feel like,
I'm sorry.
Bingo on the zombies. Thank you, Selena K. 5 memberships. Thank you so much.
Will he be here on the evening of the 3rd, or is he? Okay, so he'll be here the evening of the 3rd, so we would be putting him on the morning of the 4th, which is probably all we would do.
Wow, CJ.
Have extensive costs.
Criminal trial, hung jury, not fun.
Like I said, this is something you all can talk about over lunch. I am happy to do 2 half days or a full day. We don't have to. We can just do the afternoon of Friday.
That sounds reasonable.
Both of you want
that might be the case, Kathleen.
I'm really a big fan of Friday afternoons also. I'm a big fan of Fridays.
As am I.
Everyone's like, I want a 4-day work week.
Scheduling hearings on Fridays.
I like a 4-day work week.
They're always at 1:30. I mean,
usually 3:30 on a Friday.
Kathleen, thanks for the super chat.
That's the old 13.
60 hours might be the number.
4 o'clock on Fridays.
I don't think it's just the 13th that does that. Anything else? Because it's almost the anointed hour.
Not from the plaintiffs.
I love Judge Boyd. Communication is key.
Not this time,
She has so much wisdom and just a huge heart
Clerk,
too.
you're okay with the exception of you're waiting on those 2.
And she won't take no bull.
Received them? Yes, Your Honor. Great. And one thing I was thinking about is when you're receiving these flash drives, are you marking them such that they're
identifiable?
Once they go back to the jury.
There's several on one. I don't know if you want them to separate them or just leave it as
Well,
is.
ultimately, if they are all on. If they're all
yes, we have
admitted,
testimony today, Maisel. It's about to start. Jury's going to come in just a minute.
If there is an issue with one,
Then it's separate, Your Honor.
but the whole thing is, what if the jury, if they're not labeled on the physical flash drive, we're going to have to make sure that the jury has them labeled on the flash drive. So
Judge Stephanie Boyd will get the flowers on the 2nd, so it should be Monday.
Plaintiffs didn't do that. Well, we'll have to figure out how to get those marks so that when they go back to the jury, they're not messed up. Okay. My intent was to, when I bring in the jury, I'm going to read the instruction that we discussed at the end of the day yesterday, and then just go into the first witness.
I don't know if this is a contingency case
for
the plaintiffs.
Let's bring in the jury.
If somebody knows, that would be interesting. Contingency means, Amanda, thank you for the question, by the way, that the lawyers are working for free, assuming that, well, they're working for free now because they're going to take a percentage of the cut later. And so they, that's the contingency. If they win, they get paid. So. The fact that lawyers will work on contingency is beneficial to people who don't have the money to afford a lawyer. The flip side is if there's a settlement, the lawyers usually take 30%. Krista, thank you for gifting a membership. That is awfully kind of you.
Please be seated.
I went to Holly Henderson.
Good morning.
Good morning.
Happy Friday to you.
As well, same to you.
Hope you all got enough sugar back there this morning.
What?
You're welcome.
They're all wired.
I want to
They're gonna fall
confirm that
asleep.
while you were away, you did not discuss this case amongst yourselves. You did no investigation. You received no information. Is that correct? Yes. Now, I just also want to confirm that since you were last with us, that you have not been approached by anyone about this case. Is that correct?
Krista, thank you. I'm sorry I didn't see
I want
that.
to confirm, since you were last with us, that you have not seen any sort of media coverage about this case. Is that correct? Okay. Members of the jury, I'm going to give you a instruction. I'll be doing this from time to time. During opening instructions, I told you that Johns Hopkins All Children's Hospital reported suspected child abuse to the Department of Children and Families in good faith, and that the hospital cannot be found liable in this case for having made that report. After that report was made, the Department of Children and Families filed an action against Jack and Beata Kowalski. In that action, the department obtained a court order from the dependency court authorizing the department to take custody of Maya Kowalski on October 13th, 2016 at 2:30 a.m. in the morning. The department's custody of Maya Kowalski was supervised by the dependency court in that case. The dependency court made the decision to keep Maya Kowalski at Johns Hopkins All Children's Hospital after October 13th, 2016. Only the dependency court was authorized to transfer or release Maya Kowalski from the hospital or to return custody of Maya Kowalski to her parents. You have heard witnesses suggest that Johns Hopkins All Children's Hospital, quote, took, end quote, Maya Kowalski from her parents. Johns Hopkins All Children's Hospital did not take custody of Maya Kowalski away from her parents on October 13, 2016, and Mr. Kowalski is not making a claim in this lawsuit that the hospital did. However, Mr. Kowalski claims that Johns Hopkins All Children's Hospital falsely imprisoned Maya Kowalski on 3 specific occasions. First, he claims that the hospital falsely imprisoned her for a period of time between October 7th, 2016, the first day that Maya Kowalski arrived at the hospital, until October 13th, 2016, when the dependency court's order gave custody to the department. Second, Mr. Kowalski claims that Maya Kowalski was falsely imprisoned between October 18th, 2016 and October 20th, 2016, when the hospital placed her in a room by herself and videotaped her for approximately 48 hours. Third, Mr. Kowalski claims that Maya Kowalski was falsely imprisoned on January 6, 2017, when hospital employees placed Maya Kowalski in a room, removed some of her clothing, and took photographs of her body. Johns Hopkins All Children's Hospital denies that it falsely imprisoned Maya Kowalski on those 3 occasions. These 3 false imprisonment claims are not claims about Maya Kowalski's custody and are not impacted by the dependency court's custody order. The plaintiff's claims for medical malpractice or battery are not affected by the dependency court's order. Okay, having given you that instruction, plaintiffs, call your witness, please.
Okay, that was the curative that the defense requested due to the witnesses that said the hospital took Maya. That's the whole reason that happened. There were 3 witnesses so far that have used that various terminology close to that the hospital took Maya. And the defense has been asking the judge over and over for that. That was their response. I think it was a fairly balanced statement. How the judge added, it wasn't just that
I'm not sure I understand
the witnesses were wrong.
Signals.
I'll raise it later. Thank you.
Should have been at the end of the case.
Here, face the clerk and raise your hand.
Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth? Yes, sir.
This way.
Let's see. Who do we have here? I talked over it. Who's...
Good morning.
those are the folks you're going to want to talk to here. Please state your name for the record.
Marissa Higgins.
Marissa
And where do you live?
Higgins.
I live in Gainesville, Florida.
And how long have you lived there?
4 years and 4 months.
Where were you born?
Concord, Massachusetts.
Okay. How did you end up in Florida?
My mom moved me down when I was 12 to live closer to my grandmother.
In today's standards, that makes you a native.
Exactly. It's been a long time.
All right. So you went to school down here, and what did you eventually become, profession-wise?
Doctor of Physical Therapy.
Okay. And in this period, well, tell us a little bit about your background, training, and experience then towards achieving your doctorate in physical therapy.
I went to University of Florida for my bachelor's. I majored in applied physiology and kinesiology. During that time, I also played collegiate lacrosse, so I had a very strong pull towards the body and whatnot. In addition to that, I also was very interested in chronic pain and helping patients that had experiences with depression resulting from chronic pain.
Okay. And after that, did you pursue any additional degrees, or?
I received my doctorate of physical therapy, but in addition to that, I have increased specialties. I'm a certified brain injury specialist, a board pediatric specialist, and neonatal touch and massage specialist.
There's Ugly Betty, the vehicle in your picture.
I want to take you back, if we can, to the summer of 2016. And at some point, you were Maya Kowalski's physical therapist?
I think it was 2015, yes,
15,
sir.
I'm sorry, 2015. Okay, you know this better than I do. And so I wanted to ask you whether you were the person that made the initial inpatient rehab physical therapy evaluation on July 31st?
I believe that was the date, but yes, I did do her initial evaluation with Maya, and her dad was there as well.
Now, if it would be difficult for you to remember each and every part of this, or would it be difficult for you to remember each and every part of this without seeing it?
I would prefer to see it if possible, but...
Would that refresh your recollection?
Yes, sir.
May I approach you? Or we can put it up, I mean.
Well, if you've got it there, you can just approach.
That's right, I can't put it.
Thank you very much.
Was that the evaluation?
Yes, sir.
Okay.
Your Honor, just for the purposes of the record, can you identify what the base number of the date is?
That's not an objection. That's just an ask for a clarification.
I know it's 3047. Can you read on the bottom? It says Exhibit 3047.
-1378.
Yes, and then the last page.
The last page says Defense Exhibit 30471384.
Oh, that's right. I was just reminded that we can publish to her and counsel, and that way I will know what I'm talking about.
You can do it by the paper, or you can do it electronically, whichever way you want to do it.
Okay. So I want to take you through this a little bit, and we can publish to those that can receive it right now.
Wait a second. Are you showing a document that's in evidence or not in evidence?
This is not in evidence.
Okay. So members, hold on a second.
To the jury, hang on. Instruction to the jury really quickly. Judge is going to explain how this is going to work because the public doesn't get to see this document. She gets to review her notes because it will refresh her memory.
Members of the jury, since the document's not in evidence, I'm turning your screens off. So that's the reason why you're not going to be able to see anything. You can proceed at this point.
So, tell us about the first time you met Maya.
Maya came in and her father was there. I can remember doing the assessment on the therapy mat in our gym. And overall, she presented with significant weakness throughout her not only her legs, but her upper extremities, her arms as well. Maya had significant discomfort with movement through her knees and ankles. In addition to that, she was very apprehensive in regards to someone else initiating movement due to the significant discomfort.
Now, through this examination, from time to time, the jury will see Maya moving her arms and legs. But in terms of CRPS, paralysis is not one of the elements, is it?
No, sir. And
she can move. I'm sorry.
No, I'm sorry. I was just saying, and it can be very inconsistent, the presentation, just due to the symptoms that are experienced day by day.
And did you observe this throughout the time that you took care of her?
Yes, sir. There were days where she felt much better than other days, and the days that she wasn't feeling well, she really did struggle and experience discomfort during her sessions.
Okay. I'd like to show you what has been marked as Trial Exhibit 2529-035. And this is in evidence, Your Honor.
Is in evidence?
It is in evidence.
Mr. Rice, take down the other document first.
Yes, sir. Just a moment.
So they just showed the wrong thing. The jury got to see something they're not supposed to see. Oops. Did you get your screenshot, guys? You got your screenshot of that? They make mistakes in this court.
Okay. Now, when you first saw Maya, this is a photo taken right around that date. Did she appear to be in significant, well, maybe this was later because she's got the boots on. Did she appear to be in significant pain?
Yes, sir.
And what were the ways, can you tell the jury, you could tell that?
She was 9, so crying, saying that she was in pain. Occasionally she would writhe in pain. And just the fact that she was limited from doing the activities that a normal 9-year-old would want to participate because she was nervous about experiencing increased discomfort.
So did you observe instances where you would move to touch Maya and she would shrink away or otherwise react?
Yes, sir.
Did she have good days and bad days?
Yes, sir.
Okay, take the jury through, if we can, your initial assessment, what you did, how you did it.
Well, first I wanted to get to know Maya, so I would ask her questions about previous to this exacerbation or the hospitalization, things that she enjoyed. She was very quick to tell me she was going into 4th grade, but it was much more like going into 5th grade because she was in advanced. And she just showed her personality like any other 9-year-old during that. And then from there, I did a range of motion assessment, seeing how much she would let me move her hips, her knees, her ankles, while monitoring her for pain. And then in addition to that, I did a strength assessment of those various muscle groups throughout her hips, knees, ankles, etc. The way that we split up with our therapy in that facility was PTs would typically take a look at the lower body, so legs essentially and trunk, and then OTs would focus on what's more called fine motor skills, so more the hands and the arm movements. So in addition to that, each evaluation with patients at TGH, I would look at their ability to perform mobility, so rolling, sitting, seeing if she could stand, walk, and transfer from an object like a bed to wheelchair, wheelchair to mat, etc. And then just looking at the assessment here, just because it has been 8 years, it looks like she was able to have trace movements through her legs. So if you think of if you were to go do like a bicep contraction where you feel the muscle, but not necessarily active movement, that was happening around in her ankles, where you could kind of feel the muscles going like they wanted to, but they were inhibited by the discomfort and the pain. And then some hip movement, like able to move through partial range, but not against gravity. So if you think of if you were laying flat on a bed and I asked you to Well, sorry, that one is a 1, so never mind. If you were laying on your side on a bed and I asked you to kick your leg, she would be able to move that a tiny bit, but if I asked her to lay on her back and kick up, she was unable to do that, so that's called anti-gravity movement. So did that answer your question? I'm sorry.
Okay, well, I wanted to then show you, well, let me ask you, did you then begin your inpatient therapy?
Yes, sir.
And can you remember everything that went on in that, or would you need assistance to do that?
I mean, by everything, you mean 24/7, I would need assistance.
Everything you
yes,
did.
sir.
Would this refresh your recollection?
Yes, sir.
May I approach?
Why don't you tell Mr. Shapiro or show him what you're going to show the witness?
This is how court works. Please show the opposing counsel what you're about to present to the witness.
May I approach, Your Honor?
You may.
It shouldn't have to. The judge should not have to give these instructions.
Thank you.
So let's tell the jury that was almost the same day, or was it the same day that you did the?
The day that I met her was the day that I did the initial evaluation.
And so then this was the first actual visit?
Yes, sir.
Okay. Explain to the jury what you did and how she reacted to that.
So I overtalked the first round, so I apologize. So I did the strength assessment, the range of motion assessment, and with that, she was experiencing discomfort, especially through her ankles and knees. So I was unable to get her to her full range of motion of her ankles. So if you think of standing up, how your feet are able to go into kind of a 90-degree angle, she was unable to achieve that because she was so limited by pain. I do recall that she was tearful during this first time, which is fairly common because she's in a new environment and you have people that you don't know or trust yet moving you, and she's experiencing pain.
Let me then, so how long did the physical therapy last?
That session or for,
Yes, ma'am.
I'm going to look at this real quick. Usually they were about 45 minutes. It was 30 minutes for the evaluation.
Got it. So let me show you then, and this is in evidence, Your Honor. Well, let's make sure I got the right one here. This is in evidence as 2529-025. And if we could display it, Your Honor.
Yes, you may.
So you should be able to see it there.
The other side's told what the item is,
And I'm
so they
old
can make
school with it.
objections if needed.
Okay. I will, for the record there on the bottom left-hand corner, there is a timestamp. And what is that? Can you see?
August 6, 2015.
Okay. And so this was what, about a week after you started?
Enhanced.
8 or 9 days?
Yes, sir.
Okay. How was Maya doing around this time? I see she's not got boots yet, but tell the jury what you were doing with her and how she was doing.
So over time during that week, it came to my attention that she had significant discomfort with weight bearing through her legs, so standing up, putting weight through her feet. So I tried to change up the activities to enable her to elicit some leg strengthening to the best of our abilities with making it as less painful, to decrease the pain as much as possible. So in this particular instance, what I'm doing is I positioned a table with a fun game off to the side to enable her to lean to the side to elicit what's called a righting reaction or an equilibrium reaction. So basically with that, if you were to get kind of pushed over to the side, if you were going to get pushed over to the side, the first thing that happens is that your trunk engages, and then by that means your hip and leg will contract as well. So I was able to get her to strengthen through her quads and her hips and her trunk muscles in a way that decreased pain and decreased fear as well, because it's critical with pediatric patients to make it a comfortable environment and to build rapport with them as well.
So let me then show you trial exhibit 2529. I can't see the last numbers. This one, can you all make that out?
Enhance.
It's hard to see out here.
Yeah, it's 23, Greg.
23.
Some would say enhance the numbers for us.
It's in evidence, Your Honor. May we publish it to the jury?
You may.
Well, it looks like we have. Okay, so
Looks like
here,
we have.
explain what's going on. What's she trying to do?
I don't believe this was my session. However, this is called an upper body ergometer on our Motomed unit. So I believe what was happening here was that she was using the arm cycle to help get movement through her arms, to help with blood flow, help with strengthening, etc. You can see kind of with her hand placement there that she wasn't able to fully grasp it due to pain, due to weakness. But I believe that this session was focused on that to just try to help with endurance in any way possible, as well as seeing what strength we could get.
Now, had you seen that expression on her face previously or after?
Yes, sir.
Is that an indication from your experience with Maya that this was what you would call a bad day?
Yes, sir.
And on those bad days, was her ability to be touched affected?
Yes, sir.
And how about her overall presentation? Was she, appearing to be less functional on those days?
Yes, sir.
What did you notice on the off days then, that overall about Maya's attempts to recover?
They were limited. She was experiencing pain. She was sad. She was frustrated. And that had tremendous impacts on her abilities to participate.
Okay. And then I'll show you what's, let's see what that one is.
Nisik? I don't know how to pronounce your name, but welcome to the gallery.
I'll show you one.
Give me a pronunciation guide and I'll try to remember it.
Trial Exhibit 2529-026, and it's dated August 10th. It's in evidence. May it be published?
If it's in evidence, yes.
Okay, so again, you can see on the bottom here, it's 8/10/215, around the same time. And what are we trying to do here? Particularly, what is that on her legs?
Okay, so she's in a Riften gait trainer, and on her legs, it looks as if we have the PRAFOs, PRAFOs on their positioning devices for the lower extremities. And because she had the weakness and that fact that she couldn't really achieve that neutral positioning through her ankles, we wanted to make sure that her ankles were well supported so that we wouldn't experience ankle sprains with weight-bearing activities, so putting weight through the feet. So if you think of kind of like a rollerblade or a ski boot, it helps secure laterally to prevent her ankle from rolling. And then she's on a weight-bearing support harness, and then she can weight bear through her arms through those upper extremity supports as well.
All right, well, close then to that time, let me show you, I want to get into the boots.
Yes, sir.
When Maya arrived, did she display dystonia? And you're from, obviously, with the feet turned in? This is before she started with you.
Right. I remember that she definitely experienced plantar flexion where they're pointing down. I'm just going to look at this real quick. And she was unable to tolerate foot flat positioning and sitting. With that, so yeah, so her feet were definitely pointing down.
Okay, let me show you then what's been marked as Trial Exhibit 2529-031. A few days later, August 8th, 2014, may be published.
Is it in evidence?
It's in evidence.
Yes.
Okay, now what's on her feet here?
Those are those PRAFOs that I mentioned before.
Did she like those or not like those?
She did not like those.
She complained they hurt?
Yes, sir.
But what were they designed to do?
Prevent injury and prevent further contracture development. So she did not like them, but I did not want her to get injured. So it was the lesser of two discomforts.
Right. Was her foot then trying to turn one way and the boots were holding them another way?
Yes, in a more neutral alignment.
Now, by this point, had it become clear to you whether Maya was sincerely trying?
Yes, sir.
Okay. I'd like to show a short video from that same day, Exhibit 2658. It is a video of August 14th, 2015, and we'll play it, and then I'd like to have you then tell the jury what your impressions are, what was going on by this about midpoint.
Yes, sir.
May we publish?
You may.
We didn't even move 5 inches. Come on.
You can do it. You can do it.
Move. Come on.
Come on, righty.
Giddy up.
There she goes. She's
Giddy up. Hurry up. Hurry up.
There she goes.
Come on. Giddy up.
Are we up right there?
Giddy up.
Okay, come on, left.
Lefty, come on. Let's go. Come on, you'll get a break. You don't believe me? Well, too bad. Let's go.
Come on, left. Come on, bring her forward, bring her forward, bring her. There it is. That was great, Maya.
What is this going on?
Come on, come on.
Love it.
Yeah. Very good. Very
good. Maya.
Go left.
Very-
Giddy up, Percy.
Giddy up, Percy.
Giddy up. You don't believe me?
I do.
Come
Let's
on.
go.
Good, good, good.
Woo!
Good.
Good. That's it. Maya, that's awesome.
Very good.
Okay.
She stops
You-
verbalizing
you're
here.
almost my
You
mommy.
can tell she's in pain as she's
Almost
doing
there.
this.
I was going to tilt her that way.
Yeah.
There we go. Here we go. Whew.
You both are getting a workout, aren't you?
Yes.
Do you want me to put the stool close by you, Marissa?
You know what? We are almost here. Well,
Okay.
I can make it. I can make it.
All right.
We can make it. Let's go, Lefty. Come on, Lefty.
Go.
Come on.
Come on.
Come on, Lefty. Just go forward. Go forward.
Okay, pick it up. Good.
Is that straightened on your own?
That was good.
Can you press up a little bit for me?
Giddy up, Percy. Go.
There you go.
Come on, righty.
Come on. You're doing it.
Toes forward. Toes forward. There you go. All right. Come on, Lefty.
Come on. Move it. It's not going. What's my fault?
You got it. You got it.
Talk it to it. Come on, you gotta talk it out.
Go. Go, go, go.
You got it. You got it. Nice and tall. Nice and tall.
Spank the horsey on the butt.
There you go. There she is. Nice job. Sorry, Maya. Trying to get the best position here. There you go. You got it.
Go. You delete it right after I see it.
Okay.
Nope. Toes forward. Toes forward. There you
Good.
go.
Good job.
All right.
There we go, Maya.
Done.
Done?
Oh no, we have 5 more feet. Here we go.
Go, go,
Come on.
go. Go.
Come on, Maya. Bring her forward. There she goes. Keep going. Keep going.
It sounded like she said,
Pull it up.
There we
then
go.
delete it
Pull,
right
pull,
after
pull.
I
You
see
got
it.
it. Kick, kick, kick.
Pull it up. Good. Pull it up. You're almost there. Almost.
She's coming. Come on.
Oh, yeah.
There we go.
Oh, very good. Very good. Keep going.
Keep going. A little bit further.
Kick
a little
it
bit
up.
further. Kick, 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 kick.
Kick to the front.
So I can't do it anymore.
Are you sure? Can we try one more step? Okay.
Okay.
Okay, a few questions. First, does this indicate that Maya was in your opinion, trying as hard as she could?
Yes, sir.
Now, who took the video? Do you recall?
Yes.
Who was that?
Maya's mom, Beata.
Okay. I noticed that Maya, when you were walking with her, her shirt came up a little bit and she immediately pulled it down. Was she pretty, as a 9-year-old, I guess, was she pretty body conscious in terms of displaying? And
I believe so.
Well, you weren't standing in front of her, obviously.
Right.
So. Okay. Now let's talk about Beata. She was encouraging Maya during the time since she was there?
Yes, sir.
How often was she there? Or is it mostly Jack? I don't know.
It was a combination of the two. I don't know the exact number of sessions I worked with Beata, but I do know that I met her multiple times.
And did you have an opportunity to speak with her?
Yes.
And did you have an opportunity to explain Maya's progress?
Yes, sir.
And through the course of your back and forth, can you tell us whether Beata appeared to be normal? That's a bad word. Whether Beata was first conversant with her daughter's condition, she knew what it was and challenges?
Yes, sir. Yes.
And had you been involved in terms of working with a lot of parents before this?
Some parents before this, yes,
Okay.
but lots since.
All right. Well, based on your experience both before and after, was Beata acting appropriately under those situations?
Yes, she appeared to be a loving mom that was invested in the health of her daughter.
Okay. And did she have any hesitation to encourage Maya, as we saw there?
No, sir.
I'm going to show you then Exhibit 260, and I'm not sure again. Oh, this is another video of August 27th, 2015. But before we do that, I just showed you that about, I think, the midpoint. So by the midpoint of her therapy, how is she doing?
There were good days and bad days, but as you could see in there, that while it wasn't necessarily pretty or how we walk, we were at least able to progress to the point where we could get upright, that we could try to get more and more weight bearing through the legs and trying to progress towards the activities of daily living. So I would say from that July 31st date to that, I believe it was August 14th date,
Right.
that there was progress. Yes, sir.
Audrey, we're just happy to have you here.
Yes, sir.
Wonderful. Thanks for
For a
joining
variety
us.
of reasons.
Yes, sir.
If we can help
She
at all, let us
had
know.
a lot of pain and discomfort.
Right. And so then, did you continue with the boots throughout the remainder of her time there?
During that time, I believe I had a discussion with Beata during one of the first sessions where I had met her, and she had asked about the boots for positioning. And from there, we developed a schedule for her to wear them throughout the day as tolerated. And then she would wear them as tolerated during therapy sessions.
Okay, I want to go back to an exhibit we've previously shown the jury, but I think I had the timing wrong. This is trial exhibit 25229-035, and I believe the date of this is approximately the 20th or so. Now, were there days where Maya had an extremely difficult time with the therapy and wearing the boots?
Yes, sir.
All right. And during those days, would she be allowed to recover a little bit?
I think with that, I think it depended largely on the therapist. For inpatient rehab, she had to have, I think, about 3 hours of therapy each day. So that would usually be about 2 PT sessions, 2 OT sessions. So I think it was largely dependent on each specialist that would see her. I can speak for myself, where if she had a more difficult day, that I would try to focus on the things that we could accomplish versus the things that would cause more discomfort and trauma.
So was this inpatient care?
Yes, sir, inpatient rehab.
So she was there at the
She
hospital.
was living in the hospital at this time.
And were her parents constantly there to support her after? And the times when you weren't in therapy, I don't know if you know or not, but from what you saw, were her parents consistently with her to try to support her, one or the other?
I think they were there as much as possible. I know that she had a younger sibling at home as well, and they had jobs. But I would say in comparison to maybe some other patients that I had, her parents were there more frequently.
Okay, now I'm going to show you a video a little later on towards the end there, and it's Exhibit 2660. It's taken August 27th, 2015, excuse me, and it's in evidence. May we play it, Your Honor?
Thanks, Audrey.
Yes.
Good to have you
It's
here.
short.
Oh, nice to see you. Nice job. You got it, you got it. Whoa!
Oh, she
So
was
by
about
the
to
end
score.
here, had she made
You
some
cut
progress?
it. She was scoring
Yes,
right there.
sir.
You
All
cut
right, so
cut it
looks
right
like
before
she
you.
was using her upper body fairly well.
Yes, sir, and her trunk.
But were you able to get her out of the wheelchair?
I think for that session, I think there were some sessions that I focused more in sitting. There were sessions that I focused more in standing. So I think with that one, I was trying to play as well for strengthening.
I'm not so worried about the therapy part.
Yes.
The fact that by the end of this, despite your best efforts, was Maya still in a wheelchair?
Yes, sir.
She still could not stand?
Not without copious amounts of assistance.
And so soon after that, her stay ended?
Yes, sir.
And so overall,
Pardon me.
then, from your perspective, having worked with her for a month inpatient, was Maya Kowalski suffering from any unusual or difficult personality traits that made you think perhaps there was something wrong mentally?
Object beyond the scope, and that's the objection found in lack of foundation.
I'm going to sustain it.
Let me rephrase.
Yes, sir.
What, if anything, did you notice about Maya Kowalski's mental status in terms of friendliness, outgoing, and ability to relate?
Maya was a highly motivated, intelligent young woman who was eager to participate as tolerated.
Mm-hmm.
She was friendly. She would laugh. She had similar interests to other 9-year-olds her age. I would say in comparison to other 9-year-olds that I have met, besides being maybe more intelligent, she is fairly similar.
Was she in the Shopkins stage yet, or was that later?
I don't understand.
A little bit.
Okay.
And Beata Kowalski, from your interactions with you, was there anything that put you on guard that perhaps there was something, ulterior motives, or something going on with Beata Kowalski that concerned you?
Objection beyond the qualifications of this witness.
Later.
I'm going to overrule the objection. The answer stands.
The witness is like, actually,
No,
it's
sir.
not. You guys, just be mindful. We're only hearing one side of the story so far. We realize the side that we're hearing is the same side that was presented by the Netflix documentary. There is a whole defense that will be presented, and a lot of evidence and a lot of information that is not going to paint the family in the brightest light that currently the plaintiffs are painting them in. So just be mindful of that.
Should I even try to repair this?
We're early in this trial.
Yeah, that's fine.
Did it just get worse?
Hey, good morning.
Good morning.
There's a lot of dates thrown around this courtroom, so I'm going to try to orient you. The time for which Maya was at Tampa General was July 31st, 2015 through August 26th, 2015.
He just said the 27th a second ago.
Okay. I'll show you the record, I promise you.
Yes, sir.
Okay, all right. So I'll represent to you that she was admitted on July 30th, 2015. Okay. This is not yet in evidence, although I suspect it will be. But I would ask.
Move to strike editorial.
This is not yet in evidence, but it would help to refresh your recollection if I showed you your therapy note from the first day that you saw her.
I have it right here.
Okay.
But yes, sir.
Okay.
Well, wait a second. If she has it, then I don't have to do the...
So your first note was the first full day of the hospitalization, July 31st, 2015. Is that right?
I believe that to be true.
Okay. Do you have at the bottom what's labeled defense exhibit? Well, is the first page of your note show a note that says inpatient rehab physical therapy, today's date 7/31/2015, defense exhibit 440? Is that your first page?
My first page, can I give you the bottom numbers of it?
Sure.
Okay, defense exhibit 3047-1378.
Okay, so we're on a different page. Your Honor, if I could have Clay published just to the witness, 3047-0440, please.
You can put it up now.
Okay. This is your note? Okay.
Yes, sir.
Okay. The referring
Apparently we get to see
physician
this too.
is Dr. Kornberg, correct?
Yes, sir.
And who is Dr. Kornberg?
He was a physiatrist at Tampa General Hospital.
Is he sort of overseeing your therapy?
He's our referring doctor, and we would update him.
Okay. Let me, Clay, if you could go to Defense Exhibit 3047-442. And then part of your therapy sessions, you would make notes about how Maya's doing. Is that right?
Yes, sir.
So let me direct your attention to where you have a comment under other. Do you see that?
Yes, sir.
Okay. You wrote that Maya was unable to isolate contractions during testing, but demonstrated increased functional strength when performing activities subconsciously.
Yes, sir.
So let me ask you this. When you asked Maya to do something, is it true that she told you she couldn't, but when she was distracted, you noted that she could?
I don't believe she told me she couldn't. I think what happened with that is that when you try to isolate a muscle, it is hard to physically do it. However, when you're able to overpower with momentum or able to do it when it's a bigger, more integrated task within the body, it can occur.
Okay. You noticed that Maya was able to do things subconsciously, had greater abilities subconsciously at this visit than when she was conscious of it. Is that true?
Objection. Overruled.
With that, it was like what I was explaining earlier on the therapy ball, when working on things like writing reactions, which are reflexes within the body. Reflexes are able to be elicited more readily.
Okay. Let me ask you about,
They're saying,
you
was
were
she
her
faking?
therapist throughout the whole hospitalization.
On the days that I worked, yes,
Okay.
sir.
So let me ask you about a note from about a week later on August 6, 2015, and that will be Defense Exhibit 3047-344. You list comorbidities for the patient. What do you mean by comorbidities in general? What's a comorbidity?
This is a tool done.
Comorbidities are
They have a
just
tech specialist that's doing the highlighting
things
for
that
them.
you're experiencing. So it can be pain, it can decreased range of motion, things like that.
What did you chart as a physical therapist? You have to also chart what might be a barrier to discharge. Is that right?
Yes, sir.
And what did you chart on August 6, 2015 as a barrier to discharge?
It appears that I put attitude of family, attitude of self, comorbidities, but these were links that carried over from other therapists as well.
Okay. So is what you're telling this jury, both from other therapists and what you put in, that one of the barriers to Maya going home was the attitude of Maya and the attitude of her family?
In terms of limitations due to pain.
And then let me ask you about another record that you wrote on August 11th, 2015, which is at 3047-288. Again, just turning to the part where you were doing transfers, you also noted that there were inconsistencies during treatments when asked to perform weight shifting with the trunk. Is that right?
Where does it say this?
On the top part where it says patient demonstrated inconsistencies during treatments when asked to perform weight shifting with the trunk.
Yes, she had good experiences, bad experiences.
Okay. Well, you also wrote on the next section, wheelchair training and management.
Mm-hmm.
You wrote, you attempted to perform wheelchair training during physical therapy. Maya demonstrated difficulty using bilateral upper extremities to propel wheelchair forward, despite being able to maneuver her wheelchair around obstacles previously. Is that right?
Yes, sir.
Okay. And then on on the next page, 289, again, one of the barriers to discharge was attitude of family and attitude of self.
Again, there's carried over.
Okay. And then again, let me ask you about 247. Actually, let me ask you about, let me ask you about 145 and 146. Let's start at Defense Exhibit 145.
Gotcha, Ayden. We just announced it as news. Let's try not to talk about it. I'll make a little comment in a minute.
So again, you were asked a question about mom being present during your therapy. Do you remember a time when mom was asked to leave the hospital?
I do not recall that.
Okay. Do you remember psychiatry or psychology be involved in that decision?
I don't remember the decision in which you're speaking of.
Okay. Do you remember whether Tampa General also put Maya on video monitoring?
I do remember that.
Okay. Were you part of that decision?
No, sir.
Do you remember why?
I believe she had an instance where she fell out of bed and they wanted to make sure she was safe.
Okay. Let me ask you, so we'll just fast forward to the end because it looks like you were her therapist all the way through. Actually, I'm going to ask you about one more note and then we'll get there.
Yes, sir.
Let's put up Defense Exhibit 3047145. And I'll represent to you, this was a progress note on August 21st, 2015. This is your note?
Yes, sir.
Okay, so Clay, we'll go to the bottom where it says other.
Are you guys getting commercials?
You wrote, patient stood in standard for the duration of physical therapy, that she participated in games involving her bilateral upper extremity coordination as well as reaching. She demonstrated improved tolerance to standing as well as weight. And then if Clay, you go to the next page.
I know YouTube's going to turn them on here any day now, and I won't get a choice on that. But for now, you should not have any.
Maya did not report increased pain or discomfort in the ankles through the entire session, but when the patient's mother entered the gym, her complaints of pain increased in frequency. Is that right?
It appears to be so.
Okay. And then you were her therapist on the last day of discharge, so we'll go to 3047-73. And just one last question for you. Again, you said it carried over right through the day of discharge. Tampa General in their therapy notes, including yours, wrote one of the barriers to Maya going home was the attitude of the family and the attitude of Maya. Is that right?
It appears to be so.
Okay. One moment.
So the attitude of family, attitude of self is not as big as the one before that we just heard, where it said that. Let me see if I can switch this to camera.
You recommended.
1 second. We're going to go warp
Maya
back in time.
continue
Just 1
with
second.
Intensive physical therapy after discharge.
There we go.
You recommended Maya continue with intensive physical therapy after discharge?
Yes, sir.
And that would be important for somebody like Maya?
Yes, sir.
Okay. Do you know how often she went to physical therapy after she left?
I had no contact with Maya since the day she discharged.
Okay. That's all. I appreciate your time.
I appreciate you. Thank you.
Thank you.
Any redirect?
Okay, so the big statement was that when Maya's mom was in the room, the patient complaining of pain seemed to increase. That was a huge admission in the favor of the defense, and it just gives you an indication of what we're going to start seeing from them.
When Maya came in, did you receive records from other hospitals, including Johns Hopkins, All Children's Hospital?
We received a discharge summary from wherever she was admitted from. I don't recall if it was All Children's or St. Joe's. It was one of the local hospitals.
Okay. And when there is a suggestion of, or a whatever you want to call it, working diagnosis, whatever, is it carried over into the Tampa General records?
Oftentimes, yes.
They didn't object because it was literally reading out of her reports.
Influence the perspective of those watching the patient, in this case Maya?
Oftentimes, yes.
So if presented with a narrative about a child, have you found in your career that oftentimes the narrative is completely false?
Objection. Speculation.
Overruled. You can answer.
Thank you. Can you repeat the question?
Have you found in your career that these narratives that appear from other hospitals, doctors, whatever, are in many cases false?
Yes, I think people have biases that they act on. Yes, sir.
From what you saw, felt, heard, sensed with this family, particularly Maya and Beata, did you see any indications whatsoever of anything unusual that would put you on guard to think there was something wrong there?
No. That calls for a legal conclusion.
Wrong?
Wrong.
Was on guard was what you said?
I'm not sure.
Ask the question again.
All right. From everything you felt, heard, saw with this family, did you note anything, whether you put it down or not, that indicated to you that there was a concern for something not right with the family?
Objection calls for speculation.
Overruled. You can answer that.
No, sir.
Your witness.
Just one redirect. Just one question, if I may.
Yes.
Your notes, the ones you entered in the record, those were made on your independent observations and conclusions after spending time with Maya. Is that fair?
Yes, sir.
Okay. And you expected, based on what you saw, the progress that Tampa General made with Maya, that she would continue to improve. Is that fair?
Yes, sir.
Okay. That's all, Your Honor. Thank you.
Members of the jury, at this point in time, do you have any questions?
Sorry.
Can I have the attorneys come up?
Why is that one going first? I'm trying to line up a couple feeds. We have some jury questions. Those are coming in right now. Let's see how those turn out. There we go. All right. I appreciate. I did put some news up there that involved a political figure passing away. I would ask that we not make any political or comments about that. I've told you over and over that I would be the first person to sign up somebody who's the opposite political opinion of me to help them register to vote, even if their vote is cancels out mine. I think more people involved in the process makes it better. And I do think even though I have my own personal feelings about how long people should serve, I think people who do sign up and serve in public office should be commended for being willing to do that. And I think more people should do it. But I think if more people would sign up and try to run, it might fix problems that sometimes come with long terms of service. But that's all. No more politics on that bound. And Ivan, sorry, I timed you out. I thought it was sort of funny. That's too political for today. We'll just go back to the case at hand. Janice, thank you. 4 months. So glad to be here in this community. Everyone is so nice. Thank you. The community is absolutely incredible. So it makes this the best place to watch. And I'm not talking my channel. I'm talking with you guys. This is the best place to watch true crime. Thank you so much. A lot of times you guys are on another channel, and that makes that the best place to watch. So thank you.
Okay, ma'am. The jury had a few questions.
Yes, sir.
Did you ever observe times when you could not touch Maya or assess Maya due to pain, for example, in her legs or arms, etc.?
There were instances where she was experiencing so much discomfort that I had to shift my therapy sessions so that I would not have to touch her legs. So then I would focus on other things like core strengthening or something along those lines, or shift it more to a play activity to where I could possibly get some strengthening without physically having to touch her.
The next question. As a therapist, why did you continue to document a barrier for discharge attitude of patient and attitude of family? Could you have changed that and not carried that over?
Because I was a young therapist and did not pay attention to the hyperlink that went through. So some of those that have the long lists, it was if one person touched it, it changed it for everybody. And it was something that I must have missed during that time. And I apologize for that.
Plaintiffs, do you have any follow-up questions based on the jury's questions?
As a young therapist, then, you were under the direction of others at the hospital, is that right?
I practice under my own license, but did I experience mentorship? Yes.
Okay. And so sometimes other therapists or doctors would enter things in the notes that you did not necessarily agree with?
In their notes, yes. And within the therapy team, sometimes, like with the hyperlinks, those carried through.
Understood.
Briefly, Your Honor, thank you. The video that the jury saw with Maya slapping her legs, getting up horsey, hitting her leg with the gate belt, that wasn't uncommon for her to encourage herself that way, was it?
I don't believe it was uncommon.
Okay. Talking about the note, just so the jury's clear on this, the vast majority of your note is your writing.
So where it says the things like general observations, let me see if this is the eval or the treatment note. Also, excuse me, I haven't worked at Tampa General for 4 years and 4 months, so give me a second.
I might be able to redirect you to the question I'm getting.
Thank you. I appreciate it.
No problem. I know this is probably not the most fun day. What you're telling the jury about the barriers to discharge, some other therapist noted that and put it in the record, and you just didn't change it?
It appears that way, sir.
Okay. I appreciate your time.
Members of the jury, are there any further questions? Okay, we've got another question coming.
That was a great question by the jury, asking about that comment with the attitude of family, attitude of self, regarding the barriers to discharge, and they drew out an answer that basically she said that was from someone else, that I was basically, it was pre-populating, or I would import notes and it would fill up that it was somebody else's observation, it wasn't her own. I don't think it's falsifying records so much as just an oversight. Her inexperience contributed to that. It's amazing that she owned up to that and claimed it. She still seems to have claimed the part about the patient's experience of pain increased when the mother was present.
Paw prints, smiling pile of poo, smiling pile of poo.
Hey, Rebecca. Good morning. Good to have you here.
Okay, ma'am, there's a few more questions.
Yes, sir.
Please describe the difference between a diagnosis and a narrative.
In our instances in this field right here, or like at Tampa General, the working diagnosis that we would work with was whatever Dr. Kornberg, our physiatrist, provided. I would just like to look at the notes too, if you don't mind for a second. In addition to that, I'm so sorry, PT diagnosis. So in terms of PT diagnosis, I would also go into more depth of their impairments that are observable. So for example, in her treatment note that I have here, or in her eval that I have here, I believe that I put, these were very lengthy notes, a PT diagnosis: impaired strength, impaired range of motion, impaired balance. And then as far as narratives, that's how I try to describe what I'm seeing so that I can write more of an assessment over time. So for example, PT diagnosis: decreased range of motion. Our ankles aren't moving as far. Decreased strength. We're having trouble moving against gravity. Increased pain. We're having pain with our activities. My narratives then would go into more of my treatment sessions, or kind of what I'm seeing. How is the body positioned? How does she have to move her body to get other parts of her body to move? How is she presenting overall? What's her posture? Things like that. So I would say my narrative more goes into, okay, let me take this snapshot of what I'm seeing in this moment, whereas my diagnosis is some of the things that are staying consistent throughout, the things that are causing how I'm creating the narrative. I'm sorry, I'm fumbling on my words.
The next question: when differentiating between a narrative and diagnosis, is that distinction made only in hindsight?
I don't believe so. I think a lot of the times it's coming during the session as well, that I'm taking the diagnoses, like I said before, and those are in my mind as I'm treating. So I'm looking at this decreased range of motion, the pain, the decreased strength, and then I'm looking at, okay, how can I adapt this to help her? And then that's where the narration is coming into play.
Plaintiffs, any further questions?
I think when
Yay.
There are two types of narrative. One is where you dictated in what your notes are, and another one is from the course.
Subject to the leading, Your Honor.
I'll rephrase. So the narrative, in terms of narrative, what you were testifying to was your narration into your records of what you saw. Would that stated?
Yes, sir.
Do you recognize there's another version, term, definition of narration? I'm not even talking about narration. Narrative, which means there is a
Objection leading, Your Honor.
Sustained.
Right. Do you know the term narrative as it relates to a stream of facts, not yours, but that are passed
Objection to
on?
the narrative, the leading, Your Honor.
Can he rephrase the question?
Okay, this is what we're going to do. I agree with Mr. Shapiro. Sustain the objection. Why don't you try it one more time, and if not, you need to move on.
What narrative are you talking about versus the other narrative, and explain?
The narrative I am talking about is my the objective things that I'm seeing in a session. And the other narrative, I think I'm missing the understanding of maybe what the question was. I'm sorry.
It was not a very good question. Let me try one more time. Are you familiar with the passing along of facts without verification from one hospital to another without
Mr. Anderson.
verification?
Mr. Anderson, I agree with Mr. Shapiro.
Move on.
Have you?
I get it now. Is that fair? Can I?
No.
What about the other narration? Is that better?
One's objective, one's subjective. I would say what I was saying was subjective reaction to what I'm seeing in a session, whereas the narration that might go through are biases that people share from time to time. So what I was talking about was concrete facts of what I was seeing from Maya during the session, as opposed to relying on maybe people's biases that have been shared from time to time and things like that.
Thank you.
Mr. Shapiro.
Nothing further, Your Honor.
Members of the jury, I think there was another question.
Yes. Let's go.
Yes, let's go. This is an interesting court. The setting, what gets allowed here. The eye look, the little open eye glance we just saw from the plaintiff's attorney. No, she'll get them on Monday, Holly Mack. I mistakenly told you it would be the 28th, but I think we originally had the 28th, and we decided to wait until Monday so they would get there and she'd have them all week instead of having them, predominantly over the weekend.
I think there's only one question this time.
Wow.
Were there times when Maya experienced heightened pain when not in her mother's presence?
Yes. Sir.
Plaintiffs,
And
any further questions?
None for plaintiff.
Nothing further, Your Honor.
Members of the jury, any further questions?
You sure?
May this jury.
The juror said yes. May this juror be excused. He's like, yes, please. I'd like off.
I appreciate that. Ma'am, you're free to go.
Thank you, sir.
Is she released from subpoenas and all that?
Very much so.
Okay. You might want to leave quickly. Obviously, we're all laughing, and when the transcript reads, I don't know what it's going to read like, but there were a lot of laughters in the last few moments. Okay. Plaintiff says your next witness is going to be more than 15 minutes.
Yes, Your Honor.
Members of the jury, I think this is a good time for us to take a morning break. Do not discuss this case amongst yourselves. Do not do any investigation and receive no information. One other thing before you leave. There was a question from one of the jurors about this morning's instruction, and in due course, we will be addressing that, but not right this second. Okay. Have a good break.
Okay. I have a suspicion that this judge is not going to shave for the duration of the trial. And he may end up looking like ZZ Top, or he may just develop a full beard. But I'm thinking I need to have a contest with him and see who can wear it better as this trial progresses.
It seems like we have several members of our jury that might need to audition for McCurdy's comedy club. Are there any issues we need to address before we leave?
A trial beard, it's a thing. Is it for good luck? Is it for good luck, or is it just...
Bar.
Okay, let's try to keep this to about 10 minutes, 10-minute break.
Is this the famous Mr. Shapiro? The name sure is famous. Okay, that was interesting. Could we resurrect the trial goatee for us? I've got the full scruff going right now. I have not trimmed it down to a goatee. That is what I'm the least effective with is the trimming part. And that's usually how my goatee ends up disappearing as I try to shave it just a tiny bit around the edges, and then I go too far, and then I'm trying to balance it out, and pretty soon I just have a little stripe down the middle, and it doesn't look good at all. So, Brandy has the brows, you have the beard. We'll need longer trials because the brows can go on in a moment. The beard takes a couple weeks to really get in shape. Maybe it's like when a sports fan wears the same underwear repeatedly for good luck. I think they only do that in hockey. Right? Oh man, if you guys have ever been in a hockey locker room, first of all, you won't want to go back unless you really love the sport. But wow, pungent does not begin to cover that. I was a cameraman for a live stream, a television live stream of a hockey game, professional hockey game one time, and they had the bright idea because they had run a cable and said, hey, we've got the ability now to run a cable to the locker room. We can actually, and it was so they could watch things there, but we disconnected the TV and used it as a signal feed so I could send my camera feed from the locker room back up to the live stream. So here we are live streaming TV, and so during the break, I run down to the locker room. Well, guess what happens in a locker room? They didn't care that I had a camera there, and it was everything I could do, because this was live television, to not point it at men who were in various states of undress. Let's put it this way. The language was atrocious, and it was sending a live audio feed, and I'm trying to tell people to drop fewer F-bombs. Okay, the coach was going nuts, and he was one of the worst. And I'm supposed to film the pep talk in halftime and things. We've got the injured players that are stripping down in the towel, headed to the ice bath, and it was a riot. Oh my goodness! I think they only did it one time, and I'm pretty sure the station I was filming for got hit with an FCC fine because of what aired from the locker room. Anyway, thanks Tish for reminding me of that fun experience. Let's see. Yeah, I was filming a lot of heads. Because it's one thing when you've got a camera on it, it's a shoulder-mounted camera. Okay, so it covers up one eye. One eye sees just what the camera sees, and a lot of times you're zoomed in and narrowed out. And you also get no peripheral vision on that side. So if somebody's moving that way and you're panning, you have no warning about what's going on in the background. So if someone's coming out of a shower or headed into the shower or something, well, coach is pacing the room. Oh my goodness, it was nuts. It was nuts. That's all I'll say there. All right, going back to the trial, what questions we have about this, specifically about this witness, Dr. Marissa Higgins, physical therapist. I think the influential stuff they got in. First of all, the video of Maya attempting to walk. And I realized a lot of people had questions like, why would someone film their parent doing this? And you have to sort of put it in context to figure out why, because she was getting to this point after having not been able to get out of bed or having not been able to get in a wheelchair. For the family looking at Maya's physical therapy, this would be a huge success, something to celebrate. This is like, I never thought we'd get to this moment. This isn't so much, look how much pain my daughter's in, although she was. This was something to say, you're doing so well. And when Maya looks up and sees the camera, okay, and says, and I want you to delete it right after I see it, okay, she wants to see her own progress, but she doesn't want other people to see her in pain and struggling. And her modesty also, as her shirt was riding up a little bit because of how she was being carried, probably came into a factor. And that I think was important on a couple issues, especially as we get to some of the allegations against the hospital, specifically when it comes to how they treated her and her modesty and things like that. Tammy L., welcome to the gallery. Good to have that green courthouse by your name. Thank you so much. Let's see. Are you going to grow out your goatee? I think I might for a little while. I'm going to trim off the sideburns and the beard part and go back to the regular goatee. I usually start pretty wide, so it's like it's not quite the Fred Flintstone look, but I start wide and then I trim it down. Therapy involved playing cards with family and family having to slap her leg with no warning. It was to train her brain to not respond to the pain. I haven't watched the Netflix video, so if that's in there, I don't know anything about it. I will say it did resonate to me a little bit with the therapist, having personally received an injury and had to go to physical therapy for it. The therapy that's done, it's not done to cause pain, right? It's not. We need to get you to tolerate as much pain as possible. But the way she described specifically how when you ask her to move her leg and she can't lift it, but when you push her, she will. That reaction, I understand how that works, and I understand how they use that effectively, and why she was able to see different results with a subconscious reaction as opposed to a focused singular muscle reaction where pain was involved. So I personally thought that was good testimony. I don't think that her admitting to the mistakes on the reporting, as far as just populating or allowing someone else's remarks to remain in her comments, I don't think that damaged her. Even though she said she was brand new, she admitted that at the very beginning that she was a brand new patient and her brand new physical therapist, and Maya was like her first patient. Let's see. Winter is coming. Time to grow out. The manscape. Leave mine all year. Closer to ZZ Top than to Babyface. Okay. Illinois Mama. Okay, that makes sense. And on this topic, you made the comment about the family having to tap the leg or something like that. In Maya's case, in the video, where we also saw some tapping of the legs, where Maya herself was slapping her leg a little bit, trying to get it to go. What we don't know is the pain level that she was experiencing, the constant pain level to touch, where we know there were some good days and some bad days. I would venture that if they were trying to help her to walk at that time, that was probably one of the better days where there wasn't just pain to touch, where she could be touched or moved. And Maya doing the touching as well, and how she does it was, I think it was okay. It didn't show that she could be touched because she slapped her own leg and said, "Giddy up, horsey," as she's trying to get her legs to move. Let's see. The video of her dancing just made my little heart explode. Jessica, it was amazing. It's very touching. At the same time, it scared me to death because I realized we're playing copyright music, and I'm like, oh no, there goes my live stream. We're about to get banned. You have to be very careful with copyright music. That's no bueno. They don't mess around with that. Let's see the. Beata recorded everything, extensive notes and all, and without it, there's no way this case would have made it here. She did exactly what she should have, probably her gut instinct. Amanda, I think we're going to see, and it might be hard to see because the hospital is going to have to present evidence from their side that paints Beata in a different light, that paints the family in a different light, and even Maya in a different light. And so once they start presenting evidence, and we're just getting a taste of it right now, because right now we have the good witnesses for Maya. We have the people who are on their side, who are saying positive things that are furthering the plaintiff's case. There's a whole other side to this trial, and once that starts happening, there are going to be some angry people because there are going to be some things said and brought out that aren't pretty and don't look good. But we do have to wait for all the evidence. We are in a break right now, Ella. Had a little bit of lighthearted humor at the end with some commentary involving witnesses being excused and you better run while you can type thing. And jurors, the judge misspoke and said, "Is it all right to excuse this juror?" And one of the jurors like, "Yes, please. I want out." Let's see. Beth says they'll send you a warning first. I've never got a warning. I've only gotten strikes, Beth. Maybe I just not know where to look for it, but I've never seen a warning. I've had claims and strikes. Only one strike on this channel, but lots of claims. Audrey, thank you. Our mods work overtime and do an amazing job here. Let's see. Appreciate the kind words, Jessica. Let's try not to be too judgmental. We have a lot of people with a lot of different experience in chat. We have doctors, we've got nurses, we've got people who currently are diagnosed with the same disease that Maya has. We've got people who've used or abused various medications that are involved in this trial. We pretty much have the whole spectrum covered, and we appreciate the perspective that gives us. We just ask that when you do share your perspective, even though I'd say for you it's truth. I'm not discounting anyone's experience. Just understand that other people have some experience in the same field, in the same area that might be different than your experience. Just share thoughtfully that way, and we can all be friends at the end of the day. We've got people who are afraid of doctors. The apple a day, right? Tulsa State Fair last night. Anyone from Oklahoma? What, Michelle, what was the as far as the foods? What's the strangest food that's sold at the Tulsa State Fair? Because every state fair has like a unique item that people buy at it. P. Will, I got a strike on, not on this channel, I got a strike on another channel. I got a backstage personal tour with a musician, a performer, and that performer told us about a composition he wrote and designed, and he made on his own composition, and I asked if I could film it, and he played it for me. He played a version of that, and he played it for me. That performer's recording company hit me with a copyright strike, in spite of having all the permissions from who I thought was the copyright holder. They hit me with a strike, but yeah, it's interesting. I get claims from on almost every single verdict watch. Almost every single verdict watch claims it from, even if I'm, a pool camera, a pool media outlet approved on a case, I still got claims on verdict watches. Mayla's mom, is this a thing? Brain sandwiches? I'm scared to ask. I'm scared to ask. Donut hamburgers and cricket pizza. Oh my goodness. Maybe I shouldn't have asked. Wow. I could do the donut sandwich, but the pizza I think is going to have to go. Nope. Let's see. Jimmy, I'm not sure about as far as the medication. I'm not extremely well versed in that area as far as drugs. Fried Snickers. That sounds good. I've had fried ice cream.
Okay, please be seated, everybody.
And we're back. anyone know what that camera-looking thing is below?
Issues that we need to address.
Yes, it's a pan
Not
tilt.
issues, but I think we have an agreement about the day off next week. I just didn't know when you wanted to tell the jury so they
It's a
can
pan tilt
know
zoom
that before
camera,
lunch.
and it's. I'll tell you when we're using
What
it.
is
Ready?
the agreement?
Both sides would prefer to take Friday off as opposed to 2 afternoons.
Ooh, we get a long weekend.
So all day on October 6th, all day October 18th. I will tell them all day on November 3rd and possibly November 2nd. I'll tell them before they run to lunch, so if they need to start scheduling appointments or whatnot,
this is a long trial.
they can do that. Anything else?
Judge, we would like to publish one admission on a response to plaintiff Maya Kowalski's request for admissions. DIN number, I never find that, but it was e-filed on 5/28/2020.
We can show it to Your Honor.
Or I could just read it.
Did they say objection?
I didn't know if you wanted to give an instruction or not.
Publish, Your Honor.
Why don't you put it up on the screen?
Oh, I'm sorry. Just number one?
No, there's two. There's two. They're, the
There
same.
are?
They're largely the same, but there's two.
Oh. You're on.
You did say one.
You did say one. It's the only thing I saw.
Okay. Waiting for the explanation here. Rule out whether Maya had reflex sympathetic dystrophy or a variant of complex regional pain syndrome. The counsel's talking to each other right now, so that's why the mic's muted.
I'm just going to stand up and read it.
Okay, because the style is the old style.
Oh, I'm not going to worry about I'm just going to say defendants, Johns Hopkins All Children's Hospital.
Let me see, is there an instruction I need to give before the publishing of a request for admission?
I haven't seen a standard one, Your Honor. It's usually something similar to the depot where you tell them what it is. Maybe they came out with one and I'm behind the times.
Judge, for the record, we object to the relevance. I'm not clear on exactly what the purpose of this is at this point.
I think we're going to hit 200 today for sure. So yes, the camera is right on the judge's desk. That is a pan tilt zoom. It can aim, it can spin in circles. It
Well,
can
this
look
is
around the whole
akin to a
courtroom.
stipulation, essentially. It's an admitted fact.
There's no question it's a fact. The question is whether it's a relevant fact.
Turkey leg, street corn. I love street corn.
Pediatric neurologist never evaluated Maya to rule out whether she had CRPS. That's not relevant in this case about CRPS.
As to All Children's Hospital, we believe so. But again, I'm unclear on what the purpose of it is with this witness, or perhaps counsel's just publishing it now.
I'd like to publish it in the middle.
Well, I feel like I need to give it some type of instruction to explain what's.
Want us to come up with one?
Well, I'm looking over at Mr. Altenburn.
Is there a standard on this?
Mr. Altenberg's all about the jury
There
instructions.
isn't a standard on admissions, Your Honor. It's in 301.1, it appears to be E.
For the stipulations?
It says, well, right under stipulations D, and what I'm looking at, E is admissions, and since it's applicable to all parties, it reads members of the jury. Johns Hopkins All Children's Hospital has admitted certain facts, using must accept these facts.
Say this is admitted. Read it.
That's what I'm going to do.
So don't I read this?
Yes.
Sure, I'd love the court to read
You
it.
normally read the admission as well. The lawyers.
I think I'm supposed to read the admission.
You're supposed to read the whole 9 yards. What the jury instruction committee.
Give it to him.
Yes.
Lots of whispering going on.
Yeah, actually, Mr. Whitney, what din did you say it was?
Do we know what din it is?
The ties are quite colorful today. I approve.
I'm just making the font a little bit bigger.
If somebody can recommend a good tie, I need a new tie. I've worn the same 3 ties for a couple years, and I need a new one. So if you find one and can send me the link on the burner phone, please let me know. I have the suit that I bought is probably closely. Let's see if we go back to court. It's lighter than charcoal. It's a light gray, but it's not like a super light.
Okay, so to recap, I'm going to read members of the jury. The parties have admitted certain facts. You must accept these facts as true. And then I'm going to say that during Maya's sheltering at Johns Hopkins Children's Hospital from October 2016 through January 2017, a pediatric neurologist never evaluated Maya to rule out whether Maya had reflex sympathetic dystrophy or a variant of complex regional pain syndrome. Also, during Maya's sheltering at Johns Hopkins Children's Hospital from October 2016 through January 2017, a pediatric neurologist never worked with Johns Hopkins Children's Hospital to rule out whether Maya had reflex sympathetic dystrophy or a variant of complex regional pain syndrome.
Okay, so Mr. Shapiro's suit color is the closest to the suit color that I have. He's sitting right behind the Elmo right now in this picture. I wear it with a white shirt. It's for church, but the printer's going. Yay, ASMR.
I'm just bumping up the font. There we go.
Anyway, so
And how long do you anticipate this witness to
I can
last?
detect nice quality of ties, but I have zero taste in a tie, and it has to be like
minutes on direct, Your Honor.
something I could wear to court. So a pickle tie probably is not going to cut it.
After this witness, or is there another witness after this witness?
We thought if we can get this thing done, we would give the jury the option, but I would think they would probably want to burn on through because the next one, we're doing Barr first or Spiegel?
Barr first, then Spiegel.
Barr and Spiegel. The next one should be about the same amount of time. Barr did and maybe a little less because Spiegel just did the barometrics and Barr only saw her once. So they're not.
I don't mind taking the jury to lunch at 12:30, but if it looks like it's going to be much beyond 12:30, I'll call it after the first witness, and then we'll take lunch.
Okay.
Okay. So let's bring in the jury.
Katie, the only thing I know is I can see from the type of questions they're asking. Oh man, hang on. Love the printing. They have to print like 4 copies of everything too. The type of questions they're asking on the cross-examination gives us an indicator of what they're going to talk to, as well as we heard the opening statements. So that's what I know. As far as the actual details, who they're going to call and how this is going to be presented, we don't have that information. A very subtle pickle print. It'd have to be very, very subtle.
Okay, everyone, please be seated.
Maybe I could
members
make
of
a
the
tie
jury,
out
I
of the
want to
jury.
confirm while
Out
you
of
were
the-
away on break, you did not discuss this case amongst yourselves, you did no investigation, and you received no information. Is that all correct? I also want to confirm on break you were not approached by anyone about this case, and that you, while on break, saw no media coverage about this case. Is that correct? Okay, members of the jury, the parties have agreed to certain facts. You must accept these facts as true. 1, that during Maya's sheltering at Johns Hopkins All Children's Hospital from October 2016 through January 2017, a pediatric neurologist never evaluated Maya to rule out whether Maya had reflex sympathetic dystrophy or a variant of complex regional pain syndrome. 2, that during Maya's sheltering at Johns Hopkins All Children's Hospital from October 2016 through January 2017, a pediatric neurologist never worked with Johns Hopkins All Children's Hospital to rule out whether Maya had reflex sympathetic dystrophy or a variant of complex regional pain syndrome. Okay. And that concludes the reading. Now we're going to move on to our next witness.
Witness called Dr. Carl Barr.
I'm getting some pretty cool ties texted to my phone.
Dr. Carl Barr.
The Jerry Garcia one, Baby Bear. That's fantastic. Okay, I heard Barr. Is this Carl?
Doctor, if you'll stand here, face
Dr. Carl Barr?
Do
you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, nothing but the truth?
I do.
This way, please.
I've got two feeds. This one has a lot more saturation on it than the other. The other one looks more like this.
Thank you. Would you please state your full name
Sort
for
of
the
pasty
record?
on this one.
Carl Robert Barr.
And Dr. Barr, have you been called here today as a pediatric neurologist?
Yes, that's correct.
And have you been called here today to testify about your interactions with the Kowalski family
Yes, I have.
and your treatment of Maya Kowalski?
Yes.
I have your CV here. I'd like to start with your background, training, and experience. If you could just give the jury the benefit.
That means this is probably going to be an expert
through medical
witness.
school.
I received a Navy scholarship to go to medical school, and I attended Philadelphia College of Osteopathic Medicine from 1990 to 1994. And then following that, I went back on active duty and did a medical internship at National Naval Medical Center in Bethesda, Maryland. It was a transitional internship and also met the requirements for internal medicine. Following that, I did a adult neurology residency at, it was changed from
it's sort of neither
to National Catholic Consortium for Graduate Medical Education, which combined the training programs at Walter Reed Army Medical Center, National Naval Medical Center, and Malcolm Groh Air Force Hospital at Andrews Air Force Base. So I completed 3-year adult neurology residency program, and I was fortunate to be accepted to go into a child neurology program at Walter Reed Medical Center, which I did 2 years of training in pediatrics and child neurology.
Can I stop you there for a moment, Dr. Barr? During your child neurology training at Walter Reed,
yes, sir.
Would you give the jury an idea of some of the types of conditions that you treated?
Well, Walter Reed was the preeminent hospital for the Army system, and so we received patients from all over the world that had numerous rare and challenging conditions, many metabolic disorders, a lot of peripheral nerve disorders, head injuries, the whole gamut of child neurology, basically.
Would you characterize complex regional pain syndrome as a peripheral nerve disorder?
When you look at the definition and the condition, often it starts as a peripheral nerve disorder, but it presents challenges because it often spreads and does not confine itself to a single dermatome. And over time, you get what we call central sensitization, which means you have changes within the central nervous system that kind of perpetuate the pain syndrome in the way it's perceived.
All right. I stopped you midstream there. If you were talking about your child neurology training at Walter Reed, if you could continue with your background training.
So while I was at Walter Reed, I had the opportunity to do training at the Armed Forces Institute of Pathology and Neurologic Disorders. I also did time at Johns Hopkins program at Kennedy Krieger Institute, which dealt with a lot of unusual and metabolic disorders. And I also did rotations at a clinic for special children, which was run by the Amish in Lancaster, Pennsylvania, and dealt with a number of autosomal recessive disorders that occur within the Amish community.
After your time at Walter Reed, was there further training?
After Walter Reed, I went to be the child neurologist for Naval Medical Center in Portsmouth, Virginia. There's always training going on. I mean, I've done training in providing botulinum toxin treatments for...
Let me ask you the question this way.
Sure.
You mentioned an adult neurology residency, and then your time at Walter Reed was focused on child neurology. Any other residencies or fellowships that the jury should be aware of?
Did you say he does Botox injections?
And you were active duty Navy?
Yes, I was.
What was your highest rank in the Navy?
I was a lieutenant commander when I retired.
And then you went into private practice following the Navy?
Yes, I did.
And how long have you been in
They'll
private
be on Monday,
practice
Tammy.
as a child neurologist?
Monday.
Since 2004.
So almost 20 years.
Yes.
Tuesday? The 2nd. They should arrive on the 2nd.
I see that your private practice includes management of neuropathies and neuropathic pain.
Correct.
Is complex regional pain syndrome a type of neuropathic pain disorder?
Yes, it is.
Would you explain a little bit about complex regional pain syndrome and how it is a neuropathic pain disorder?
So when we look at pain, we look at primarily two types. There's somatic pain, which is the typical pain that you have when you have an injury, and you're able to basically point to where the injury is, and that's where the pain is, right? But neuropathic pain is difficult. It's often a poorly localized pain, which means it's not confined to an area of injury, and it's not something that you can easily just point to and say this is where it hurts. It's more like a generalized ache, and it can be exacerbated by different changes in, sometimes changes in temperature, sometimes changes in activity levels, etc. But the key feature of it is it's not easily localizable, that you can kind of say this is where the pain's coming from, and it is something that is difficult to describe often. Right?
Well, let me ask you another question, and this is going to be challenging maybe.
Okay.
As succinctly as you can,
all right.
Can you define what a neuropathic pain condition is?
Well, it's any number of pain conditions where you have neuropathic type pain.
What does neuropathic mean?
Well, neuropathic pain, as I said, is not, so when you look at the nervous system, it's highly organized, and the nerves have different areas that they will innervate, and so that's where the pain comes from, right? So it's all anatomically based within the brain. So your brain knows, I cut my finger, it hurts here, right? Neuropathic pain, you can't do that. The pain is just there. It's not like a sharp pain often. Sometimes it's more like an ache. Sometimes it's a burning sensation. That's just the nature of neuropathic pain.
All right.
He's relaxing a little bit.
Was there
he was
a point
very
in which
nervous.
you became board certified in neurology?
I completed my board certification in 2002.
Was that while you were still on active duty?
Yes.
And just briefly, you deployed Operation Iraqi Freedom as part of the Navy?
Yes, I did.
And during that time, you gained some familiarity with post-traumatic stress disorder?
Yes, I did.
And have you been board certified in neurology since 2002?
Board certified in neurology with special qualification in child neurology.
All right, so there's a special qualification in child neurology.
Correct.
You and I have met on how many occasions before today?
Before today, once.
We're paying you for your time this morning?
Yes, you are.
All right. Would you describe for the jury, please, your experience in treating complex regional pain syndrome?
Well, complex regional pain syndrome is relatively uncommon in children. It's probably only about 5 to 7% of cases, so it's not very common. And overall, in the general public, it's 5 to 6 cases per 100,000. So it's not a real common illness or abnormality. But so it's not seen in children. I've had probably half a dozen cases over the 20-some years that I've been practicing. And it's not a very pleasing kind of a diagnosis to make for somebody because it's unpredictable and often can continue for long periods of time.
Do you have an estimation of how many patients with complex regional pain syndrome you've treated over the course of your career?
Counting adults, probably 20 to 25.
So is it true that you're familiar with the condition, but perhaps it's not the focus of your practice?
That is correct.
All right. Did there come a time in 2016, early 2016, that you met the Kowalski family?
Yes, I saw Maya and her mother at the office on February 12th, 2016, I think.
Good memory. I'd like to publish for the witness and the jury Exhibit 1039-0016, which is in evidence.
If it's in evidence, you can present it.
Thank you. All right, Dr. Barr. At the top here, just to orient the jury, we have Florida Child Neurology as the header. Is that your private practice at the time?
That is correct.
And we can see the second block of text there. Maya Kowalski was the patient.
Yes.
And as you just mentioned, this first visit was on February 12th, 2016, about a third of the way down on the page, right?
Correct.
Can we put up the timeline focused on this spring period, please? We have a demonstrative aid. We have agreement from the defense counsel to publish. So the jury has been swimming in dates throughout this trial. So I'm just going to display a timeline and ask for your assistance in
timeline
locating February 12th, 2016 on this timeline.
Sir, I'm actually going to take it down for a moment and recycle it to see if I can get the public gallery TVs back up. When in doubt, reboot.
This is the judge's IT experience on display. It has worked so far.
All right.
Let me disappear from the screen here just a second.
Dr. Barr, the timeline begins on the left-hand side on November 4th, 2015 and ends on the right side at March 3rd, 2016. And this is a partial timeline of what we've been talking about in this courtroom for the past week or two. Is it true that your interaction with the Kowalski family would have come just after the next to last entry there of an endocrinology visit to Johns Hopkins Hospital?
That is correct.
All right. Well, can we go back to Exhibit 1039-0016, please? And just keep that handy, please. The timeline, I'll ask you to go back and forth. All right, doctor, I'd like to, first, before I go there, who was in your office on February 12, 2016 from the Kowalski family?
It was just myself and her mother and Maya.
Can we, just for a moment, put up a photograph previously admitted 2528-124? Do you recognize?
Yes, I do.
And who's in this photograph?
This Beatos is the mother standing on the my left, and then Maya, much younger, is on her mother's left.
And when Maya presented in your office, was she standing like this, or was she in a wheelchair?
No, she was in a wheelchair.
Have you seen Maya Kowalski since your visit with her in 2016?
No, just now.
All right. You can take that down and back to 1039-0016. So my understanding is that this is your primary note because it was only your only personal interaction with this family. Is that correct?
As far as I recall, yes.
All right. What was your impression of Beata Kowalski upon first meeting her?
She was very, she was, in her mannerism, she was very direct in her speech. She had an idea of what she was coming to the office to try to achieve. And she was like I said, direct, but overall pleasant. She was not inappropriate at all. It was a very typical conversation that we had.
Did her behavior seem appropriate for a parent of a sick child?
Yes, she was very concerned. She wanted to do whatever she could to help Maya. She had some experience with ketamine in the past, and she was looking to see whether I might be able to help her arrange to continue Maya having ketamine coma treatment. I told her that was outside of the scope of my practice, and I didn't know of anyone in the area that would provide that service, but I told them that I would check to see whether I could arrange it, because it would have to be an inpatient service and done by anesthesia or someone who had familiarity with it.
So if I understood your testimony, Beata was a good historian of Maya's medical history?
Yes, she seemed to be very...
Check the leading judge.
Overruled that one.
Did Beata Kowalski relate to you the course of Maya's prior treatment with complex regional pain syndrome?
Yes, she did.
And if we look here, for example, at the first large paragraph here, it says, Dr. Kirkpatrick believes that the RSD was caused by a right ankle injury Maya sustained during gymnastics in April 2015. Do you see that, doctor?
Yes, I do.
And the source of that information would have been Beata Kowalski's knowledge and what she told you?
Correct.
All right. And if you look through the paragraph here, about halfway down, she also relayed to you that Maya had received treatment in Mexico?
That is correct.
And what did she report to you about how Maya progressed after the treatment in Mexico?
That she initially did well, but then her pain returned.
All right. And when she talked about the pain returning, I'm in the second to last sentence of the paragraph. Where did she say that pain typically originated?
Most of the pain was in her legs, but she, like as I stated previously, it was poorly localizable. She had pain, she said, all over. So.
Mm-hmm. And did Beata Kowalski, also relate to you other treatments that they were providing for their daughter?
Just treatment with Dr. Hanna, who was continuing ketamine.
If you look at the last paragraph here, the second sentence regarding physical therapy and pool therapy.
Correct.
And this is, again, source of your knowledge of this was Beata Kowalski.
Correct.
And her reports of Maya's history.
Correct.
All right. You can leave that up for now. But the question, doctor, is, if I understood your earlier testimony, Beata Kowalski came in and relayed that Maya had received ketamine treatments and was receiving ketamine treatments.
Correct.
Did you have a different recommendation for Beata Kowalski?
After we initially discussed the ketamine coma, and as I stated, I told her that was outside of my scope of practice, but I would check to see whether it was available I worked in both Advent Health System and Orlando Health System. So I made inquiries whether or not anyone would be willing to provide it, because I didn't have the knowledge to do that, and it would require support. When you put someone in a coma, they have to be continually monitored, respirations and other body functions. So it had to be done within a hospital, and so I couldn't find anybody that could do that. So I then suggested, because she had a history of multiple infections when she was younger, respiratory primarily, and there was some question of whether or not she had an immune deficiency, which could be an underlying cause for her pain. I suggested that we might try IVIG, which she had been treated with previously and had some benefit from.
All right. If you would talk to the jury and define IVIG. This is, I think, maybe the first time they're hearing this treatment.
Sure. Intravenous immune globulin is IVIG. And what it is immunoglobulin proteins that are separated from the blood of multiple donors. So you're basically collecting all of the donor pool's antibodies. And that is purified and then reconstituted and administered to the patient for a multitude of different conditions. And it's been found to be effective in a lot of these inflammatory type of problems. So it's relatively low risk and possibly high reward type of a treatment.
Had you previously treated complex regional pain syndrome patients with IVIG?
I have, and it's been varying results, which is common for treatments for complex regional pain syndrome.
Complex regional pain syndrome, is there a cure for this disease?
No.
There are only treatments, correct?
Correct.
And is it fair to say that the treatment of complex regional pain syndrome is trial and error?
Yes, that's true.
Sustained.
Fine. And so, did you recommend IVIG treatments to Beata Kowalski?
I did.
And was she receptive to that idea?
She was.
Did you refer Maya and Beata out for those treatments elsewhere?
We made arrangements for them to be performed at Arnold Palmer Hospital.
All right. And did they subsequently go to Arnold Palmer Hospital for the IVIG treatments?
They did go there for treatment.
Were you involved in that hospitalization or the administration of those treatments at the hospital?
I did not see her in that hospitalization.
I think it might be true that at some point after 2016, you became affiliated with Arnold Palmer Hospital System. Is that correct?
In 2021.
All right. But at that time, you had no employment or relationship with Arnold Palmer. Is that right?
No, I was private practice.
All right. Can we put up for a moment Joint Exhibit 1001-1316? Dr. Barr, what I have put up before you here, and if we could highlight the last order on the page there, it says order start date October 17, 2016. Perfect. This is a Johns Hopkins Children's Hospital record from the time of Maya's 3.5-month admission. Would you please indicate what this order is for?
So it's for IVIG infusion by protocol. And let me see. So she was receiving 25 grams, which would have been 1 gram per kilogram. And then it has instructions for the infusion rate.
Does it appear from this record that Johns Hopkins Children's Hospital administered IVIG while Maya was hospitalized?
Object to form, Your Honor. It's leading the witness, and there's been no predicate laid this witness.
Sustain.
You can take it down. What did Beata Kowalski report back to you, if anything, regarding the effectiveness of the IVIG treatment?
She had received IVIG and felt that it was beneficial, but it took approximately 2 weeks for them to see the improvement, and then it was wearing off quickly. So she had requested whether we could change the infusion spacing to every 3 weeks instead of every 4 weeks.
Was that what was the nature of that request? 3 weeks versus 4 weeks?
Well, she had contacted our office and she spoke to one of my nurse practitioners, and then we discussed it. And initially I had told the mother, or through my nurse practitioner, that I wanted to see Maya again in the office before I made changes. And we did it was difficult for them to come because it was a 2.5-hour drive. And so after some discussion and consideration, we changed the infusion interval to every 3 weeks instead of every 4.
And the IVIG treatments, were those covered by insurance?
They were.
Was there any sort of insurance impediment to switching the frequency of those treatments?
Well, so we were able to get the IVIG infusions approved for her hypogammaglobulinemia, so her low immune system problem. So whenever I do a treatment course, for insurance purposes, you always have to show that you're maintaining management of the situation. So that's why when we were going to make a change, I wanted to reevaluate Maya more for insurance purposes rather than because there was any doubt about what Mom was reporting. So it's just something that I commonly do. You have to, if you're doing a treatment, you have to make sure that you're evaluating the patient.
All right. If we could put up 1039-0004. And doctor, I'll direct your attention to the date towards the top of the page. It looks to be a phone note from July 28, 2016. Do you see that?
I do.
And so, is it true that over the course of 2016, Beata was in touch with your office?
That is correct.
And the jury will have an opportunity to review this note, but down below, does it discuss her request for a more frequent interval from 4 weeks to 3 weeks?
Yes, it does.
And what did Beata Kowalski, if you could highlight the 4 sentences of this second to last paragraph, they have been videotaping, that sentence there. What did Beata Kowalski report to you about Maya's improvements, if anything?
She stated that they travel 2.5 hours and have to stay overnight to come to an appointment. She is wondering if the IVIG can be moved from 4 weeks to 3 week intervals. They have noticed improvement for 2 to 3 weeks following the infusion and felt it really was helping her symptoms. They have been videotaping and documenting her improvements.
All right.
So she started physical therapy last week and is getting physical therapy twice per week.
Doctor, so your office was in touch with Beata Kowalski regarding Maya Kowalski's treatment for approximately 6 months.
Correct.
And you had this treating physician relationship with the family?
Yes.
All right. I'd like to now put up Joint Exhibit 1046-0001, which is previously admitted.
Kathy, we do have to keep records
Doctor,
on attendance.
have you had an opportunity to review the report of James Lewis, the clinical neuropsychologist, as it states there at the top?
Yes, I have.
If you would turn to page 5 of the report, please. And the 4th paragraph from the bottom that begins all of this testing information, if you would highlight that and blow it up for the jury and the witness. Doctor,
okay.
Before I get to this, did Johns Hopkins All Children's Hospital, after October 7th, 2016, in the period between October 7th, 2016 and January 13th, 2017, ever contact you as a pediatric neurologist?
Not that I'm aware of.
All right. If you read here from the neuropsychologist report from DCF, what is he directing Johns Hopkins to do?
Judge, I object. The document speaks for itself. He's asking one witness to comment on the testimony of another.
Sustained.
Is he not an expert? Did I get the objection on there? I'm not sure if I clicked.
If you'll turn to page 8, please. 3, 4 paragraphs from the bottom, it begins with the diagnosis of ICD-10/DSM-5.
Right.
Doctor, were you ever contacted by Johns Hopkins All Children's Hospital regarding Maya Kowalski's diagnosis of complex regional pain syndrome?
Objection, Your Honor. Number 1 has been asked and answered. Number 2, the same objection a moment ago.
Overruled. He can answer that question.
Not to my knowledge, I was not contacted.
And during this period of time, while Maya Kowalski was in the hospital, you were a board-certified pediatric neurologist.
Correct.
If you had been contacted, would you have agreed to consult with Johns Hopkins All Children's Hospital?
I would, given, there were administrative requirements that I wasn't on staff at Johns Hopkins, but if asked, I could have done that.
If that impediment had been cleared regarding privileges at the hospital, would you have been willing to consult?
Correct. Yes.
And if Johns Hopkins All Children's Hospital had asked you for your opinion as a pediatric neurologist regarding the appropriateness of a diagnosis of complex regional pain syndrome, what would your opinion have been?
Objection, Your Honor. Lack of foundation. It's an improper hypothetical. This witness has not been proven to have any knowledge of the circumstances at that later date.
Let's just keep it to the legal basis. Overruled.
Ask the question again.
I'll try to re-ask it. I won't do it perfectly, but if Johns Hopkins All Children's Hospital had contacted you as a pediatric neurologist with a treating relationship with Maya Kowalski and asked for your opinion as to whether the diagnosis of complex regional pain syndrome was a accurate diagnosis, more likely than not, what would your answer have been?
Yes, it
In this
is.
form, Your Honor, that like a foundation, like a predicate. At what point in time?
Okay, well, why don't you re-ask the question with a specific time period? But otherwise overruled.
Understood. Same question. If you had been contacted after the date of October 20th, 2016, at any time between October 20th, 2016 and January 14th, 2017, what would your opinion have been regarding the accuracy of Maya's complex regional pain syndrome diagnosis?
Objection, Your Honor, lack of predicate. No indication whatsoever.
Hey, speaking objection.
I'll be happy to approach.
Okay, I don't need an approach.
Overruled.
Overruled. You can answer the question, Doctor.
Your Honor, maybe approach.
Not on that question.
Yes, I would agree that complex regional pain syndrome was the correct diagnosis.
Whoa. Okay, this has been some rough testimony for me to listen to because the speaking style and this nervousness and stuff have made it hard to follow, and it's also his mannerism, his way of speaking is a little difficult.
Your witness.
But that was huge. Did I miss an objection? Were we at 199? They're going to go for the throat here, and I think they might be able to get some good stuff out of this lawyer for the defense side, or out of this doctor.
Good morning.
Good morning.
May it please the court.
Ma'am.
When you saw Maya Kowalski in February of 2016, is it true that you had no objective evidence of CRPS yourself?
Just my examination, but yes, correct.
Okay. So you never diagnosed CRPS in this patient, correct?
I assumed the diagnosis of CRPS.
Okay. You assumed it was correct because that was what you were given by history.
That and the history and the limited exam that I was able to do, yes.
But you had no objective findings to support that diagnosis yourself, correct?
Correct.
And you told us before, when you visited with my partner, that there are certain findings of CRPS, correct?
There are certain findings associated with CRPS, but
Right.
they're not diagnostic.
They're not pathognomonic for CRPS. What does pathognomonic mean?
It means that they're the abnormalities that you see associated with a disorder.
But they could be associated with other disorders.
Correct.
Okay. And so there's nothing that's indicative of CRPS. There are symptoms and signs that may point toward it.
Correct.
Okay. And when you examined this patient in February of 2016, you could find no evidence consistent with CRPS at that time, correct? Other than the pain.
Other than the pain, and she did have dystonic posturing of her feet sitting in the wheelchair, but
where is that in your record?
It's not in my record.
Isn't that a significant finding that should be in your record if it exists?
Yes. But I also, this is one of the problems with modern medicine and charting. We were using a scribe at that time, and so the scribe is supposed to take down things from the discussion. And so it wasn't put in the note. We have there's a standard template, and if they hit the standard template, they're not going to do it.
That scribe is supposed to take down what you tell them to take down, correct?
Correct.
And so you didn't tell them to take down posturing of the feet.
I can't remember specifically if I did or not, but I mean, I specifically recall that.
Isn't that why we have medical records, so we don't have to trust memories?
They're going after you.
But records aren't infallible, right?
They're not infallible, they're summaries, but they're supposed to contain significant findings, correct?
Objection.
I agree.
The objection's overruled. The answer stands.
So when you saw this patient in February, you didn't find any indication of changes in her skin color?
Correct.
You didn't find any indication in changes in the thickness of the skin?
Correct.
Or shininess of the skin?
Correct.
Or changes in her nail beds?
Correct.
Or changes in color of the skin?
That is correct.
Okay. And that's why you told us before that you didn't find any objective evidence yourself. You took the diagnosis from the mother, correct?
Based upon previous evaluations from other physicians as well.
Did you ever see their records?
Can the witness please be allowed to answer the question?
I have not received a record.
I'll be more careful, Your Honor. I apologize.
Thank you.
Did you see any other records?
No.
When did you review the records of Johns Hopkins Children's Hospital?
I have not.
You never reviewed the records of Johns Hopkins Children's Hospital?
I was never requested to review records from Johns Hopkins. Never provided to me.
Ooh. I see. Who have you spoken with from Johns Hopkins Children's Hospital?
No one that I can recall.
Have you seen any records of this patient's care at any point other than this morning on the monitor, other than your own?
No.
This is a huge win for
if
the
I'm
defense.
understanding this correctly, you've never seen any records from All Children's Hospital, correct?
Correct.
You've never seen any from Lurie's Children's Hospital.
Correct.
You've never seen any from Tampa General Hospital.
Correct.
You've never seen any from Dr. Kirkpatrick.
Not that I can recall.
You've never seen any from Dr. Hanna.
No.
You've never seen any from Dr. Spiegel.
No.
And you've never seen any from subsequent admissions to Johns Hopkins All Children's Hospital, correct?
Correct.
Then on what do you base an opinion what this child's diagnosis was between October of 2016 and January of 2017? Did you ever see her during that period?
Objection. It's multiple questions.
Well, I meant for the first to be a statement to predicate the question.
Objection to predicate.
Folks, you asked what was it based on. That is the question that stands, and you can answer that first question.
So what was based on was the history from the mother primarily and her physical condition.
No, sir. I'm sorry. I didn't make myself clear.
Okay.
That's what your diagnosis or what your record was based on when you saw this patient in February of 2016, correct?
Correct.
You just told counsel a few minutes ago that you thought the diagnosis of CRPS was correct between October of 2016 and January of 2017.
Correct.
You never saw her during that period, did you?
That is correct.
You never saw any records from during that period, did you?
No.
Then you have no basis for that opinion, correct?
Objection.
Overruled. You can answer the question.
The nature of complex regional pain syndrome is that it does not typically just get better. So if she was still experiencing symptoms and signs during that period, then it's likely, most likely, that complex regional pain syndrome persisted throughout that time period.
But you have no information about what signs or symptoms that she was experiencing during that period, correct?
Objection. Ask and answer.
Overruled. He can answer that question.
I don't have any objective data.
And you personally never made a diagnosis of CRPS in this patient, correct?
I agreed with the diagnosis.
That's correct.
Correct.
What was my question, sir? Did you personally ever make a diagnosis of CRPS in this patient?
No, I did not.
It sounds
when
like
you saw this patient in 2016, in February 2016, the history you were given was that Dr. Kirkpatrick had made the diagnosis in August of 2015 in Tampa. Is that right?
Correct.
And we covered this briefly, but I want to emphasize it by asking you whether you ever got any history from the mother, or anybody else for that matter, that this child had spent time at Tampa General Hospital, or what the diagnosis there was.
I don't recall specifically, but I don't think so.
You never got any information from All Children's Hospital, period, correct?
Correct.
So you didn't know that a pediatric neurologist had seen Ms. Kowalski in the summer of 2015 at All Children's Hospital. You didn't know that, did you?
No, I did not.
And you didn't know she had been to Lurie's Children's Hospital to be worked up for her pain at that time, back in the summer of 2015. Is that right?
Yes, I don't have any recollection of that.
Okay. But going back to your visit in February of 2016, you were told by the mother, did we put that up? I'm sorry, I didn't give you a reference. You don't know what I'm talking about. Sorry. 1039-0016. So if we track through the history you were given here,
they're exploiting this
because
this is a big
believes the
win for them.
RSD was caused by a right ankle injury.
They're going to get every inch they can from this.
Correct.
And then you were told she had a ketamine treatment in September that improved symptoms for 6 days.
Correct.
Is that right?
Correct.
And then the symptoms came back.
Correct.
In fact, her symptoms then recurred and were worse than before. Is that the history you were given?
Correct.
All right. And then over the next month, her condition worsened to the point where she could not eat or drink and was constantly in pain.
Correct.
Might a doctor conclude from that the ketamine didn't work?
Well, unfortunately, that's the nature of ketamine. Even when they do ketamine comas, it tends not to last. So some of the studies have shown that it will last up to 12 weeks, but mostly it doesn't persist that long.
You mentioned before that you tried to find someone in your orbit of referrals who did ketamine comas.
Correct.
You couldn't find anybody.
Correct.
Had you ever even heard of ketamine coma for CRPS to that point?
I was aware of ketamine comas being tried for painful conditions, but I didn't ever know of anybody being treated with it before.
Okay. And had you ever heard of a 9-year-old child being subjected to a ketamine coma for CRPS up to that point in your practice?
No, I had not.
Do you use ketamine to treat CRPS?
I don't treat CRPS typically, and I have not used ketamine for that.
Okay. Why not?
Well, for one, it's a very potent anesthetic, so it requires, that you're aware of all the potential side effects and have the ability to be prepared for catastrophic events should they occur with the administration. So that's usually done in a hospital setting. So you have to have a hospital that's willing to do that or allow you to do that. and you have to have the other expertise from anesthesiology or intensive care physicians to be able to monitor the patient during the time that the coma is occurring. So it takes, a team of people and the proper facilities to do that. So that's why I tried to find out if anybody would be willing to do it, but there was no, and it's also not currently an FDA approved procedure, so they were reluctant to do any of that.
Okay. And is one of the problems that you run into with ketamine withdrawal symptoms?
You can't have a with
outside the scope.
Overruled. You can answer. You can answer.
well, typically any of those types of medications you can have withdrawal from. Yes.
That's well known, right?
Correct.
So let's go back to 1039-16. And we've covered that her symptoms recurred worse after the ketamine she received in September of 2015, according to the history here. And then it says over the next month, her condition worsened to the point where she could not eat or drink and was constantly in pain. I apologize, we've covered that. And she was on several pain medications: gabapentin, Dilaudid, Tramadol, Valium, hydrocodone, Dilaudid, morphine, and several others with no improvement.
Hydrocodone.
Correct.
Never heard it pronounced the way he says it. Hydrocodone.
That was when she got referred for this ketamine coma by Dr. Kirkpatrick, correct?
As far as I understand, yes.
And then she related having had an IVIG treatment and she told you that she thought that was effective, correct?
Correct.
And in point of fact, that is why you chose to treat this patient with IVIG, correct?
That is partially the reason. The other thing is whether or not it was an appropriate treatment for her symptoms and her condition.
And you felt it was?
Yes, I did.
And it was basically a situation where you were trying the treatment to see if it worked for her?
Correct.
Okay. And did it?
By reports, it did, yes.
She got better?
She improved. She never got to where she was back to normal functioning.
Okay. But you understood that she got better and then she relapsed, if you will.
Correct.
To the point where the mother wanted to increase the frequency of the treatments.
I don't think that she relapsed. It was a matter of they saw effectiveness and then it waned. And then she had another treatment and she had improvement again.
So during this period when she was getting these treatments, she was getting them as an outpatient, correct?
She started as an inpatient and then we switched her to outpatient therapy.
And you wrote a prescription for her to get the IVIG IV, correct? Did you know that she was an infusion nurse?
Yes, I did.
Did you know she worked for Corian?
I didn't know who she worked for, but I did know she was an infusion nurse.
Yeah, I know the approach.
They're trying to stop the bleeding at this point. Defense is going to. The defense would have run with this as long as they could. They are trying to get this witness to stop talking because they're paying him and defense is using him. This is bad, but I really have nobody to blame on this one. I wouldn't blame the doctor. I blame the prosecution, or sorry, the plaintiff on this one, by bringing in a doctor who seems to be not experienced at all in this situation. And what did he offer? What was it that we were gaining from his testimony that would help the plaintiff, right? The big, other than just agreeing with some technical stuff and giving us some background and shoring up some information that we've already heard from other doctors who are more experienced and better able to present it better. The only thing we heard was that he said that that had Johns Hopkins reached out to him during that time period, he would have let them know that it was CRPS and that was the correct diagnosis. But they hadn't. Okay, so that was a huge bombshell until defense stands up and says, based on what? And this guy has nothing. He didn't look at anything, didn't look at any of the hospital records, didn't look at, I mean, he's got one quick little visit and what the mom told him, and that's it. Are you taking the football? Are you taking the football? Little RA, you taking the football? All right. So now they're trying to, I'm not sure if this discussion they're having right here is effective or not. They know that the witness is spiraling out of control and is trying to answer questions, has lost all of his direction. And now he's basically switched. They've flipped the witness, at least effectively. And so they're trying to stop him from doing this. And this pause might give the witness some time to regroup, get their thoughts back together, and focus again. But this was a huge win for defense.
Thank you,
Who did you understand would be giving the outpatient IV treatment to this young lady?
I think it was arranged through a company called Quorum.
Let me ask you a couple of questions about your findings when you examined this child in February of 2016. And I'd ask you to refer to, I asked my assistant, my helper over here, to put up 1039-18. We talked about what findings you didn't have consistent with CRPS. We haven't talked about what findings you did have with respect to your physical examination on this patient on the only visit you saw her, February 12th of 2016. She was denying joint pain and joint swelling?
Correct.
And joint redness or sports injury, correct?
Yes, as far as I can recall.
And she was using a wheelchair?
Correct.
And she denied anxiety, depression, developmental delay, behavior problems, mood changes, and inpatient admits?
Correct.
Is that right?
Correct.
And she had a complaint of eczema. What is that?
It's an inflammatory skin condition which causes lesions and a typical pattern, usually red, scaly, cracked.
You didn't find any of that this particular day?
I did not.
And then generally she appeared well, appropriate for age, but appeared to be in pain and was moaning throughout most of the visit, correct?
Correct.
All right. Now I'll skip the head, eyes, nose, mouth, neck, lungs part of this, as well as the heart and abdomen. All that was normal.
Correct.
And then you found that her muscle bulk and tone were normal for age?
Correct.
And then if we go over to 19, it looks like you found with the motor examination, with skipping over some other normal stuff here, that in the motor exam for strength, you note that she had muscle bulk, tone, and strength are normal, correct?
Correct.
Okay. And you were able to perform a deep tendon reflex examination, correct?
Yes, but she was not comfortable with doing that.
She wasn't very happy about it?
No.
And if I'm understanding your testimony correctly, this was the only time that you personally saw this patient.
That is correct.
Check my notes here, Doctor. I may be through.
I'm sorry?
I said, let me check my notes here for a moment. I may be through.
All right.
And so you personally never saw this patient after February of 2012?
Not to my knowledge, no.
I believe that's all I have for now. Thank you, sir.
Dr. Barr, was Mike Kowalski's history and physical consistent with complex regional pain syndrome?
Yes.
And although challenged on this point, dystonia is an objective sign of complex regional pain syndrome, is it not?
Yes.
And whatever your scribe took down, you observed dystonia on that visit in February of 2016.
Yes.
There is no definitive way to diagnose complex regional pain syndrome. Is that true?
Objection, you're leading, Your Honor. Overruled on that question.
Can I answer?
You can answer.
Okay. There's guidelines that are established, but there's no definitive test for complex regional pain.
The jury's familiar with the guidelines. Are you referring to the Budapest guidelines?
Yes, correct.
And the Budapest guidelines are a constellation of symptoms, are they not?
Symptoms and signs, yes, correct.
All right. So, counsel focused on the fact that many of the symptoms that would lead to an initial diagnosis of complex regional pain syndrome, which Maya Kowalski received in September 2015, were no longer present during your exam in February of 2016.
Correct. Not that I elicited, yes.
And you were aware, based on Beata's relation of the history, that she had already undergone ketamine treatments, both by Dr. Kirkpatrick and in Mexico on 2 occasions.
Correct.
So, is complex regional pain syndrome a fluid disease, meaning symptoms wax and wane?
Correct.
The fact that many of Maya Kowalski's initial symptoms that led to the diagnosis of CRPS in 2015 were not present on your examination in 2016, would you agree that that's evidence that the ketamine treatments by both Dr. Kirkpatrick and Dr. Cantu had had a positive effect on Maya Kowalski?
Object to leading. I sustain that one.
What is your assessment of the fact that many of the constellation of symptoms were no longer present during your exam in February 2016 after her initial ketamine treatments?
I'm sorry, I don't know that I understand what you're asking me.
Let me slow down. You've already testified that the symptoms, the signs, complex regional pain syndrome wax and wane over time.
Correct.
If a patient is diagnosed 6 months to you seeing them and they receive a subsequent course of treatments, is it surprising to you or not that some of those symptoms might not be present during your examination?
It's not surprising. The hallmark of when we treat a patient is we have an observation, we institute a treatment, and then we reevaluate. And so what you would like to see is that there's improvement when you do an intervention like that. And that should guide you on whether to proceed or whether to try something else.
You testified that you agreed with the diagnosis of complex regional pain syndrome. Did I hear that?
Correct.
What would happen in your practice if you refuted a diagnosis of complex regional pain syndrome, but billed for services for complex regional pain syndrome?
Object to form, Your Honor. Lack of predicate and compound.
He hasn't finished the question yet.
That makes
Why
it
don't
even
you
more
re-ask the
compound.
question?
Doctor, what would happen in your practice if you refuted the diagnosis of complex regional pain syndrome and then submitted treatment bills for the treatment of complex regional pain syndrome.
Objection, Your Honor. May you approach?
Sure.
Okay, we have, here's what we have. We have, as they're discussing this, we have an opportunity, I think, especially because court's going to be taking a break on Friday next week. We have a lot of people here in chat who have a lot of medical expertise in this area. It may be beneficial to have a little panel discussion about some of these topics, about how the hospital systems work and why some of these things are important, because this case will still be going next Friday. There are a few people that are on here that are medical professionals. We'd like to have them text my burner phone so we can be in contact with you. First, we need to vet each individual, and we'll take care of that. But if you're interested, this would be an on-camera panel discussion and a brief one. We're talking less than an hour. It's something we're thinking about for this trial. It might help us understand things as things go along. It's very difficult in chat to explain things, and we'd have a little better format, and I think it would be more beneficial to have the conversation in that setting. I think for the time being, I would not want to include patients, people who have been on the receiving end of the treatment. That might be something we look into later, but initially we're just looking for medical professionals. So if that is something that you'd be open to, and this would be an on-camera discussion with me and a couple other professionals.
Dr. Barr, you don't
not a fight,
work with
just
ketamine?
informational.
No, I do not.
Text the burner phone.
You don't claim to be an expert in ketamine?
And text me with your YouTube
You
name
would
as well.
defer to the anesthesiologists or pain management physicians that provided that drug?
Correct.
Did you ever see in your interaction with Beata Kowalski or the phone calls to your office anything that caused you concern over Beata's ability as a parent?
No.
Your Honor, calls for conclusion from the patient, from the witness. No question.
Mr. Court Reporter, let me have that question again, please.
Well, the court reporter is going to get this information. I want to show you a tie that I've selected that I'm going to be purchasing right here. This is the one. It's a big seller.
Or the phone calls to your office. Anything that caused you concern over Beata Kowalski's ability as a parent?
I'm going to overrule the objection. He can answer that one.
I did not. She was a very concerned patient, not untypical of other parents that are dealing with a child that has a severe and difficult to treat disorder.
Thank you for your time, Doctor.
Mr. Hunter.
Mr. Hunter.
For the Honor.
Members of the jury, do you have any questions?
Let's see if they have any questions.
Let's write it down.
Write it down. They already had it written down. You hear the paper tear? Rip. Here it goes. Is the burner number not working? Hold tight. Let me get that fixed.
The attorneys can approach.
The attorneys can approach. They're going to talk about these things really quickly. I'm not sure why the burner number is not working. There it is. Commands. Where's burner? Give it a test. There it is. It shows it's up and working, but there's the burner number. So I think we might have overtaxed it on a couple things. I'm not a camel. I'm not a camel. All right. So the invitation I put out, if you are in the medical profession and this testimony, if you have expertise in this area as far as the drugs, the diagnosis, working with the hospitals, things like that, if you can text me your name as well as
I object.
Object, as well as by your name. I'm asking for your YouTube name so I know who I'm dealing with, and maybe just a little background. I'm getting a couple texts in already. We'll see if we can put this together so we can all learn together and go from there. Alternatively, we might be able to also organize this a little bit better So here's me thinking on my feet over on Discord. Amber, is that something you might be able to assist with? I know you're a medical professional as well. Is that something you might be able to assist with over on the Discord? If that, would that be a better format? Discord would be better. It'll be easier to have the conversation in Discord with a group as opposed to just texting back and forth. So thank you. I appreciate that. Let's try to do that. If there's anyone interested in doing that panel discussion, being on camera, we prefer on camera. It's a lot easier to judge words when you can see faces and things like that. So no people hiding for this one. You don't have to be like up close and personal right in the camera, but we'd like to be able to see who's talking and understand what's going on. Let's see. Oh, what's the timestamp? Ivan, you did miss this right here. Let me turn this on. You missed this tie. I was doing some shopping and found this one. It was actually on the trending topics ties of the ones that were the hot sellers. So this is the tie that everyone seems to be going after. Oh, look at that! It's the same as your profile pic. What a coincidence! It's a glorious tie. It really is. We'll do some vetting. Well, definitely, this is something we'll have to do some vetting on. That's why we're saying that the soonest we could probably pull this off is probably in a week. We need some time to put some things together. Who is that on the tie? That is Ivan's profile picture on the tie. Did I miss this last objection? This approach? Did I get that on there? Did anyone tell me? Could anyone tell me? Are we at 212 or is it still at 211? Oh, you're right. Thank you, Greeners. These are jury questions, not objection. Although there may be some objections to the jury questions. So I think we're close. I've probably missed a couple because I've been sort of distracted. Nurse Steve, we'd try to do it on a Friday, but obviously if that was an availability issue and we have some great people with insights that would be very beneficial another time, we could do that. This is a trial, as interesting as it is. It's going to go for a long time, and it could very easily be something where for a portion of the trial or a portion of the day we have our discussion and then we catch up to what we missed. So it could be during the day. We'll find a time that's works with the most the most people, so we can have a good panel together. Only Dr. G. He's a different sort of doctor. He's a different sort of doctor. Love him, by the way. And Friday is his day off. That's when all the times we've had him on the channel, it's been on Friday. I'm getting some text to the burner phone on this. If all the people who've texted me, let's see, DM or ATG on Discord, or if they don't have Discord or haven't been able to figure them out, then the Facebook group is also available. Yes, direct message to Amber or Calypson's Vixen on Discord. What is ATG? ATGD. Why don't I know what this means, Amber? Can you educate me and use a crayon so I can understand? Facebook's also a way we can organize this. You're asking Heidi Ho to you says Duke or UNC. I will tell you that I'm not going to pick a battle there. I'm fairly new to North Carolina, just haven't been here for 5 years, and I'm going to say go Pirates, ECU, and hopefully not offend anybody in doing that. It's a different class when it comes to football. Ne'er the twain shall meet. It's the Tyven tie. That's right. I have a few Dr. Seuss ties, but I'm looking for something professional that I can wear. Think of in church, if I have to get up and preach, a good old hellfire and damnation talk, which is which is what I love doing the most. Can you imagine me preaching hellfire and damnation? A tie for that. No mandates. Thank you very much. Appreciate your insight. We'll collect all the individual. We probably won't be able to have everybody on that we can, but we'll try to get a spread of individuals that can represent a range of the topics as their pertinent to this issue.
Hey, Doctor, there's a number of questions that the juries have. I'll tell the jury I'm not going to be able to ask all of them, but most of them.
Wow.
Doctor, you said ketamine has withdrawal symptoms. Please clarify.
Well, ketamine, when we talk about anesthetic agents and anesthesia-type agents, many of them have withdrawal symptoms because they activate receptors within the brain. And so ketamine has action at NMDA receptors on neurons, which blocks overstimulation, right? So it prevents pain from being perceived. It also has some mild effects on mu receptors, which are opioid receptors. But if you have extensive use of ketamine, you can have withdrawal. It's not unusual with even single-use ketamine that they can have this twilight effect after a procedure, right? So that's one of the common things we see, but it's not a persistent problem. It lasts for a couple hours and goes away at the most. If you have extensive use of ketamine, then you can have other types of withdrawal symptoms, more characteristic nausea, shaking, increased heart rate, those types of things. But it's not typically seen with ketamine use.
Next question. Does ketamine have FDA listed withdrawal effects that will always occur or only possible withdrawal effects?
When we look at the types of adverse events or withdrawal effects that you have from medication, they're listed based upon occurrence. So there has to be a certain percentage of people that experience those withdrawal symptoms for them to be listed. And so it does have some known withdrawal symptoms, but any medication has potential for having some type of adverse event.
Can a person getting a ketamine treatment have no withdrawal effects?
Yes.
We need a new Discord link.
Question. What treatments did you prescribe for your pediatric patients with CRPS?
The hallmark of treatment for CRPS is pain control and therapy, primarily physical occupational therapy, and keep them moving. Because of the pain, they tend not to want to move. That exacerbates other symptoms. And you want to try to reestablish normal nervous system functioning. And so to do that, the hallmark is non-narcotic pain control, typically, and then the physical and occupational therapy. But there's other therapies that have been suggested, and ketamine is one of the treatments that can be used for CRPS.
Okay, this link should
work. Were the
work.
treatments you prescribed for the pediatric patients successful?
Unfortunately, they were not for the majority of people. The people, for one reason or another, this with conservative therapy, the physical therapy and pain control, you hope that the patient improves. So we don't have a therapy that we can give to somebody and say that they're going to improve. So you have to try multiple things depending upon how they do. So there's not one thing, but most of the time you hope that the symptoms go away because we don't have a cure for it.
Did you prescribe opioids for your pediatric patients with CRPS?
I do not typically prescribe opioids. If they have severe pain, sometimes I'll give them as a kind of an escape. So if it's so bad that they've done their regular things, therapy, mental projection imaging, those types of things, and their typical, Tylenol, Advil doesn't work, and they're having severe pain, they sometimes would give them a mild pain reliever such as Tramadol or one of the lower opiates that has less potential for addiction.
And the follow-up to that question is, if you do not prescribe opioids, why not?
Well, typically with this type of neuropathic, or what we call nociceptive pain, they're not very effective. And because they have when you have somebody with pain and you give them something to take for pain and it doesn't work and they still have pain, they try to take more. So you have a high potential for abuse and addiction. So it's generally not recommended that we use opioids for treatment.
The report states, quote, able to walk but in a wheelchair, end quote. Did you request the patient to walk during your evaluation, or did the patient state she could walk?
I tried to get her to stand, but she was unable and reluctant to, but it was stated that she was able to walk.
This is from another juror. You mentioned withdrawal symptoms from ketamine. Is there a risk of physical addiction?
There is, as I said, there is a risk of addiction. It is a drug that is abusable. And so those are things that you always have to keep in mind. And anytime, the longer that you're exposed on a regular basis to a medication, the higher the rate, higher the likelihood of developing an addiction.
The next question is, doesn't almost any pain management run a risk of psychological dependence?
Well, psychological dependence is something that we've been paying closer attention to in the last probably 10, 15 years. So there always is a risk from a psychological standpoint that someone will become dependent on medication, whether or not it has physical withdrawal effects. So that's always a worry that you have to keep in mind with any of these drugs.
And for the jury, the last question I cannot ask. Okay, plaintiffs, any further questions based on the jury's questions?
Excuse me, Judge, are we switching off while you're
Actually, it's Mr. Whitney was the...
May I ask a question?
It's Mr. Whitney's witness.
You can't have two witnesses question the same person. So now I have to pass the information to the other individual.
Should be done soon.
Oh, it's fine.
The hallmark of CRPS treatment is pain control with PT and OT.
Correct.
But primary on that is you have to control the pain.
Yes.
Overruled.
Correct.
If you don't control the pain, you can't do the rest.
Correct.
All right. You never, by history or examination, you never saw any withdrawal effects in Maya Kowalski?
None.
You never saw any physical addiction in Maya Kowalski?
None.
You were aware by this time that she'd been on some ketamine, then off for a period of time, then on some ketamine, and off for a period of time. Anything in the history or reports to indicate any concerns to you over withdrawal or addictive effects?
No.
And with regard to monitoring withdrawal effects or addiction, you would defer to her treating physicians who are providing these treatments?
Yes, I would.
Nothing further.
Hold on a second, Mr. Hunter. I think Mr. Whitney.
I think it's funny that the plaintiff started this up with, "Hey, you'll be done soon. This is only going to hurt a little bit," until the doctor that his time on the stand is almost over. It has been painful. You're going to feel a little sting. You're going to feel some pressure. It's pressure, right? Not pain. You're going to feel some pressure here.
Are you aware that the literature on physical addiction, it was with respect to street use of ketamine?
Objection, Your Honor. He's
I know
making
that-
reference to literature. He's making reference to literature without
Sustained.
proper impeachment.
Are you aware whether or not the risk of physical addiction is with street use of ketamine?
Typically, that would be where you would see it. You wouldn't expect it in a monitored treatment protocol by a physician.
Thank you.
Mr. Hunter, any further?
Just briefly, Your Honor, I hope. Please score.
Well, first of all, do you treat pediatric CRPS yourself?
Yes.
Okay. So you treat it yourself. Do you refer any of those patients?
I would evaluate them and make the diagnosis, and then we would institute treatment. If the treatment is unsuccessful, then we would seek additional help.
Do you use? Sorry, these are new lips. Do you use hyperbaric oxygen for CRPS?
I have not used hyperbaric oxygen for CRPS.
Ever heard of that?
I've heard of it, yes.
Is it FDA approved?
It's FDA approved for a number of things. I think I'm not sure if CRPS is on there.
That's all I have. Thank you.
Members of the jury, do any of you have any further questions? Okay, I see no hands. May this doctor be excused at this time?
You guys, please let me stop billing for this time.
Yeah, that's fine.
Okay. Sir, you're free to go. Okay, members of the jury, a
just
couple
rolled
of
his eyes.
housekeeping items. If you want to pull out a clean sheet of paper, I'm going to give you a couple of dates.
Uh-oh. It's time to take notes.
Just
There
make
will
sure
be
it's
a
not
test.
one that has any of your notes on, so
There will
just
be a
make it
test.
pull out a clean sheet of paper. Okay. These are dates that I know that we will not be having you in. Next Friday, October 6th.
October 12th.
So we will not be asking you to come in on October 6th, which is next Friday.
Okay, so we might do our panel October 6th if we can line everything up.
We will also not have you come in on Wednesday, October 18th, all day. So that day will not be a date that you will be reporting. Friday, November 3.
Often referred to
I
as
will
the
tell
third,
you most
not
likely November
3.
2nd, but I can't definitively tell you 100% that November 2nd is a day that you won't be in. So October 6th, October 18th, and October 3rd.
November 3rd.
November
I
3.
apologize. October 6th, October 18th, and November 3rd. Okay. So that means next week we will be here, or you will be here Monday, Tuesday, Wednesday, Thursday, next week. Now, in a moment, I'm going to release you for lunch. I'm going to ask that Deputy Coley, if you could have them back ready to go at 1:40. 1:40. Members of the jury, do not discuss this case amongst yourselves. Do not do any investigation and receive no information.
Receive no information. That sounds like he's describing my high
Have a good
school
lunch.
years. I did little receiving of information. Okay. So November 3 is what he was talking about, not October 3. Let's see if we have any business to conduct before lunch or if we get to have a full break. And then I want to say one more thing about the possible panel.
Okay, everyone, please be seated. The jury is out of our presence. In a moment, we're going to leave. I'm going to ask the attorneys to be back at 1:10, so we're going to take 1 hour. I would ask
That
that
means we'll be
the
back at
witness
1.
that we're going to need to do the proffer that she...
53 minutes.
It's a she, right?
Yes, yes, sir.
That she be on our Zoom at 1:10.
Ooh, a
And then
proffer.
I'll let her in
This will
at,
be fun.
at 1:10.
This will be spicy.
Are there any issues we need to discuss before we go on our break?
Just if they have the actual document, they were going to narrow that one document that belongs to that witness, if they have done that.
I can tell you that, trial exhibit 278111 and, no, that's not it. Hold on.
We turn on the awful ambient noise mic now
I've just got a couple, having gone through it.
because he's away from the
Will
microphone.
you be able to tell Ms. Correll in the next 2 or 3 minutes?
Yes. I'm sorting through them.
Anything else before we go to lunch?
No, Your Honor.
Is it possible to have Mr. Reyes be a participant in the Zoom with the witness to share documents?
Yes, but Mr. Reyes needs to get
Share his
the
email from the court clerk.
participant link from my assistant and the email and all that, so you need to contact her.
Okay.
Because as a reminder, my intent is I'm going to place the Zoom feed onto the big feed, which means you're not going to be able to demonstrate or show anything using the monitors, and it's going to have to come via Zoom. Okay, anything else?
No, not right now, Your Honor.
Okay. The reason why the proffer is spicy
We'll be in recess until 1:10.
is because defense can bare their teeth. It won't matter. They won't have to show. They won't have to worry about anything. They can show how angry they are at things because the jury's not there. It won't make a difference. Okay, so they can fight hard and not worry about being kind and everything else. That's why I like proffers. Also because it's like this is the battleground. Okay, the battle is fought during the proffer. It's not fought during and now we're going to act out what just happened in front of the jury. We know what's going to happen then. And usually it does get a little bit spicier and they go into some areas that they wouldn't before. But anyway, I love the proffer time. One more thing about this panel. As we've talked, we've got many people with a lot of experience, medical experience professionals on here that might be helpful to answer some of these questions. And we'll talk about those with, there's, first of all, no one's going to get blindsided. We're not trying to make anyone look bad. That if you've watched me for any length of time, that's not how we operate here. I also would love to have a varying range of opinions. So we don't want a whole bunch of yes people on here to say, yep, here's this topic, and yep, it's all right. Yep, it's all right. No, we want somebody who can challenge our opinions that we have right now. We want somebody who maybe represents the minority in chat as far as some of these issues go. So if that is you, please reach out to us through Discord or through Facebook. Amber is going to be sort of heading that up, and we're gonna try. First of all, we'd like to vet everything just so we can provide the best information from the most reliable sources we can, and that's not me. So we want to vet everyone to make sure it's all good, and then be able to move forward that way. But don't think that because you disagree with me or because you disagree with one of our polls in chat or something that we would not want your opinion. I think if anything, we want you more than ever, because that's what informs us and helps us make reasonable decisions. Alrighty, with that, it's time for lunch. Mrs. R.A. says she's going to take me to Panda Express, right? This is false, she says. No, she will not. She's taking the kids out to lunch, and I have to fend for myself. Was that what you said? I think that is what she said. I didn't misstate the facts. All right, it's been a fun morning. This is This is an exciting trial. It is more exciting than I thought it would be, honestly. It's really good. Let's see. We do have some questions on Facebook. When you apply, there's a list of questions. You might have to scroll down on the questions. Yes, you can apply. To get a mic? If you're on the panel? I'm not sure. We've got a really strict approval board. Anyway, yes, reach out to us on Facebook or Discord, and I'll try to also forward the information I've got from the text message we've got, so we can sort of correlate all the information together. Anything else we need to cover? I've got ejections on the screen. That needs to go away. There we go. Right there. That's gone. My camera looks a little better. I think more light is better, so maybe I just need a different studio. It still looks a little grainy. It looks like little bugs are flying around. Buffer posted a Facebook post for people to comment on or be able to find me easily. Thank you, Amber. We'll look for that in Facebook. If you're not able to join us this afternoon for part 2 of today's session, which I think is actually part 10 of the trial, tonight when you go home, please hug the people you love, smile at someone, make their day just a little bit better, and please stay safe till we go live again. It will be in 45 minutes. We'll be live in 45 minutes. We'll have a placeholder up in just moments. First person in chat gets to rip the internet away from Ivan's grubby little fists as he's been running it all morning. Ivan, thank you very much for that. I appreciate you. You're a great friend of the channel. Thanks for letting us rib with you a little bit. So appreciate you very much. And I'm really looking forward to my tie most of all. I can't wait for it to arrive. So on that topic, thanks guys. We'll see you guys after lunch. Have a good one. Bye.
Is that correct?